there are, two general grounds. We've addressed that in a previous response. But as it relates to this, our position is that all that Ford does is addresses whether two attorneys who appeared pro hac vice violated the professional rules. And it specifically authorizes the trial court to consider those rules when considering whether to revoke the pro hac vice admission. That is, the question was whether the attorney who is not a member of the Georgia bar would be allowed to practice in Georgia. And of course, that's not the issue here. Ford cited Piedmont Hospital versus Reddick, which had held that it was appropriate to consider the professional rules on a question of disqualification. And one of the claims at issue in that case was whether an attorney for one party violated the professional rules when it contacted another party's board members and employees. And if true, that was something that the trial court could consider in a motion to disqualify. The Court of Appeals emphasized that the right to counsel is an important interest, which requires that any curtailment of the client's right to counsel of choice be approached with great caution. Disqualification not only curtails a client's right to counsel of choice, but results in expense and delay that are costly both to the client and to the administration of justice. And they go on to say that courts have been reluctant to disqualify an attorney despite misgivings about an attorney's conduct, perhaps because disqualification has an immediate adverse effect on the client by separating her from counsel of her choice. And that's Piedmont at 76 through 77. Finally, the court held that a party did not have standing to base a motion to disqualify an attorney to file a motion to disqualify an attorney based on a conflict of interest violation that did not involve that party. In Piedmont Hospital, the claim which was rejected was one entity's claim that an attorney was disqualified because of a conflict of interest where that entity was not in an attorney-client relationship with the attorney. Here, Your Honor, the state did not violate the professional rules of ethics. We didn't violate Rule 4.2A regarding communication with an unrepresented person. The court has heard the testimony of Mr. Melnick, and the court can gauge the credibility of the witnesses after Attorney Melnick informed the state that he represented Mr. Copeland. The state had no further conversations with Mr. Copeland about the subject of this case without either Attorney Melnick or Attorney Bumpus present. And in its response to Mr. Melnick's email, the state agreed it wouldn't communicate with Copeland further, but noted that we had arranged for transportation and that an investigator would pick Mr. Copeland up the following morning for his court appearance. So that interaction was to bring Mr. Copeland to court as we had previously planned. For the reasons that we've stated in our prior filings, the hearings in chamber were proper. And even assuming arguendo that the court concludes otherwise, the state acted in good faith based on its understanding of the law. Indeed, at least 2 judges so far have concluded it was not improper. Disqualification is not an appropriate remedy under any event, especially given all of the circumstances here. We would ask that the court deny the defendant's motion to disqualify, and if there are other grounds, we would ask that the court, if they bring other grounds, we would ask that the court require that they list out all of the grounds that they're seeking so that we can address them at once, with Your Honor.
All right. Well, I think both Mr. Weinstein's and Mr. Shart's motions that are pending right now, Mr. Weinstein's for a mistrial and Mr. Shart's for a fair trial, set forth additional bases and suggest that as one of the potential remedies or grounds for relief. So I think you've The state has filed a response to Mr. Weinstein's motion on behalf of Mr. Kendrick. I don't know if y'all filed a response to the supplement, and I don't think I've seen a response to Mr. Shart's amended motion for a fair trial. So
Filed Friday.
yeah, that was filed Friday, and I'm not quite sure when the supplement was filed, sometime last week.
Okay.
So if y'all want to get something to me, can you get me something? When can you get me something?
Is Friday too late?
You can get me something by Friday.
Oh, thank you.
Okay. All right. And so I assume you have made the determination not to present any.
Design, develop, scale, repeat. Wix Studio, the platform for agencies and enterprises.
Here's the thing, aging begins in yourself. Start supporting your cell health today.
Yeah.
One more thing, we did receive the communication from Mr. Steele regarding proffers, and if an attorney rejects a proffer and insists on evidence.
With regard to Copeland or?
He sent it generally. It may
Oh.
be specific.
Oh, yeah. Oh, okay. No, proffers from an attorney. Okay, yes. Mm-hmm.
And so to the extent that that is the way that that we would move or operate, we would to therefore require, if we're gonna put up evidence, we're gonna put it up. I don't know how the court views proffers, and I didn't.
Well, I mean, I think that the case stands for the proposition that proffers are fine unless one party objects, in which case then you need to present evidence. And so.
And so if that's the case, we would ask to any circumstance where proffers, we would, if we have to put up evidence, we don't want to be dueling proffers with evidence. If it's evidence, it's evidence. But where proffers are okay, I'm okay with that.
Okay, thank you. All right, how about on the discrete issue of the phone calls, jail calls?
Yes, Your Honor. So I went back and reviewed what all we covered. So that
Okay.
got through the 5 jail calls the state intends to introduce Mr. Copeland. And I also confirmed and spoke with Mr. Sharp, Mr. Steele. We were in agreement that we handled those jail calls related to Mr. Copeland on Friday. Well,
Okay, I'm sorry, I just thought there were like 2 things outstanding that y'all said, let us huddle and then we'll get back to you.
Yes, Your Honor.
So I'm incorrect in that recollection?
In relation to the
Jail calls.
Jail calls, yes, Your Honor.
Okay, so, okay. Well, can y'all do me a favor then and refresh my recollection about what it was that was decided about the jail calls? Because I don't remember y'all putting anything before me. Did y'all just come to agreement, but y'all haven't told me what that is?
Your Honor, there was some that we agreed on. And there was, other parts where, like, for example, one of them was Detective Gaither. He asked if we could, basically we either agreed or redacted or argued those 5 calls. And it was at the very end on Friday.
Okay.
And I will get, Deputy Hilton had the notes from that, and so I will work on, and we'll get those notes from Deputy Hilton.
Okay.
Capture as well, we discussed in our.
Okay. All right, so then moving on to our next issue. Yes.
Good morning. Good morning to everyone. I agree with Mr. Atkins when we spoke last night. I think that the only outstanding issue on the jail calls for Mr. Copeland, the 5, was the redactions, and the court ordered us to look at it and then bring up any other issues with your court. So that's what I have in my
And
notes. And I think,
that's what I'm talking about.
and I think,
So,
yeah, but I don't think that the state or us have done that redaction yet. I think the state was trying to do it. If I'm wrong, Ms. Atkins, please correct me, but that's what I thought we discussed.
Yeah, and so right when we left court yesterday, when we and Mr. Shard spoke about the jail calls, and remember I had asked, we covered everything with it and we were in agreement. Yes. That's right.
And then the only thing we have to do is the redactions, and we have to look at them. That's my
yeah,
understanding.
so I think that there was, I mean, I've got highlighted now, I made a ruling on those things. So, okay. So, but yes, there was still something outstanding y'all needed to do. So
Yes.
those two little pieces of redaction, I think. And y'all were going to get together on that and figure out whether you could come to agreement.
Yes, Your Honor. I will speak with Mr. Steele and Mr. Sharp. I guess there was some miscommunication because we spoke yesterday afternoon and thought everything was recorded.
Okay.
I will speak with them expeditiously.
Okay.
to rectify that.
All right. Thank you. All right, so then our next sort of big topic we need to sort out is what, if any, part and how we're going to handle the fact that Mr. Copeland gave testimony prior to the motion for recusal and then further testimony following the motion to recuse. And we all kind of agreed, okay, things that occur after a ultimately granted motion to recuse basically need to be redone. But if everybody can come to agreement as to, you know, these things, these parts of the testimony are okay anyway, then y'all can by agreement say these parts are okay and we can move forward. So have y'all gotten together now that I believe you have all of his testimony thus far to decide what, if anything, you think, how to handle it and what you think might need to come out, if any part?
Judge, we had been in communication with the defense, and I believe that the last time that Ms. Hilton spoke with Mr. Sharp, that they were representing that the defense would get together and see if they came to some collective understanding about what it was that they wanted to stipulate to and get back with us. But if I read correctly last night, they indicated that everything beyond the point of Mr. Kendrick's motion, they wanted to do over. If I read that wrong,
I don't know. I mean, if y'all had email communications overnight, I don't know what those would have said. But does somebody want to represent to the court what the defense position is, if it's a joint position?
Your Honor, I can speak on behalf of Mr. Williams, Mr. Stillwell, and Mr. Kendricks. The stance is that everything post the recusal needs to be redone.
Okay.
Just because we feel that that's the applicable law, and that's where we're at.
All right. What about Mr. Matthews? What's
Good morning to the court. On behalf of Mr. Healy, we are in agreement that everything posted in the future file should be taken from her.
okay? And then Ms. DeWilliams, what's y'all's position? Speak into your microphone, please.
Same position as Mr. Matthews, Your Honor.
Okay. All right. So I've got another question for the defense, and that is, I think that everyone has joined into the assertion in both of the pending motions that I mentioned before that the
I apologize for interrupting the court. I think there was one more party that
Williams, Stillwell, Kendricks, Huey, Ryan. Oh. Guess, I don't know. Sorry. Nichols.
Clearly the forgotten person in this case who should be severed and who continues to object to the admission of any of Mr. Copeland's testimony against Mr. Nichols. So our first position is we object to the admission of Mr. Copeland's testimony against Mr. Nichols. Second position, that if it's admitted, it comes in with a 105 instruction.
All right, I've asked you a couple of times to give me a proposed one.
Yeah, we have it. We
Okay.
have it. We're going to give it to you prior to the time the jury comes in, if it comes in, because that's still outstanding. And
Okay.
and number three, we would, as the third layer, and alternatively, we would join the motions on the floor.
Okay. So on the proposed limiting, I mean, jury's coming back before too much longer. So go ahead and get that to me and the state so that we can contemplate language and whether, I mean, I think it would be appropriate to give, so, but don't wait till the evidence is coming in. Give me a chance to look at it beforehand.
Assumes the evidence is coming in, and I don't make that assumption since the motions are still outstanding.
I'm trying to cover things in terms of eventualities and, you know, conditionally and things like that. So I understand that. I hope you're not chewing gum. Are you chewing gum? Okay, great. No chewing gum in class. All right. So it's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
And good morning again, Your Honor. I am not waiving that
All right,
issue.
so then how do we handle that?
I thought it's two-stage. I was answering your question. If Mr. Copeland's resumes testimony, then my understanding of the rule is, or the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded and we redo it. And that's what we, Mr. Atkins sent an email last night. That's what three of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine did that in camera, if it's in camera, ex parte rather, June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right.
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to testify. You know, he could choose what he wants to do, and then we would strike everything he said.
Okay, well then let's go ahead and find that out. I mean, can you get him here so that we can explore that issue? Because here's the thing is that, yeah, if you know, everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue from
I want Lil Woody coming in there.
whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, then what then? Do we, then how do we still say, oh yeah, but I want, you know, some of that testimony, that's still good.
I thought you, and listen, I have so many, you know, going on. It's just the reality of our case.
Yeah.
But I thought you said that either yesterday or last week that we will find out whether Mr. Copeland actually wants to testify, continue testifying. And then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck, give me your notes.
Right.
That's what I thought. Now,
Okay, I just didn't understand because, and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position, it was coerced, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a, yes, if it was coerced, then we need to redo all of it. Or find out, does he at this point kind of redo are you intending to take a stand and testify, or are you going to be held in contempt?
that's what I thought.
Okay, all right, just so sounds like, well, then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course, I'm going to defer to the court. I would object to that for several reasons. One of which is that the court has had an opportunity to review what went on there. And I believe that based on what is there, right there on the transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case, I would ask that the court not revisit or go back and see if have a hearing on whether or not
Of course you don't.
he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial, and in Mr. Shart's, on Mr. Stillwell's behalf, revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but, and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but.
And so for those reasons, I would ask the court to not have us bring him in before that time that he has to testify. I'd also point out that his counsel was present.
I know.
Yeah, she gonna argue this to the death because this is good.
Okay, well, I mean, I hope that it is not up for debate that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of, purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed to be worried about a particular crime the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, this, when the statute has run on the overt acts, they're in support of the RICO. And I can't remember right offhand what the other potentially incorrect statement was about. But I mean, some of the this is or isn't perjury things are a little, I don't think, quite exactly accurate either.
Okay.
So I mean, I guess what I'm saying is you run a lot of risk, even if I say it wasn't coerced, if that is the legal determination I make. I mean, I'm saying it's a really close call. And it might be better to just pretermit that issue and deal with it a different way.
Mm.
Okay,
Did you guys
so
hear what she
when,
said?
that
It's a
was-
close
that took me
call.
to
The
question
judge
I
was
had
meeting in yesterday.
That I thought I had gotten completely wrong with respect to the motion to compel that we had filed. Because it got to a point where he's trying to not testify. We would of course ask the court to compel him to testify. And the things that have happened. And he was, as I said, he was represented by counsel, as of course I already acknowledged. But I do understand what the court is saying, and I will respond to the motion.
Okay. But I don't want to be dealing, and I can give you to Friday to respond, but I don't want to be us having no idea what we're going to be doing Monday morning. I want it sorted out this week.
So,
And your motion to compel was filed when? To compel his testimony. I mean, that was, yeah. And the order was entered on the 7th. And I don't think there's any issue that can still be in effect. I don't think we need to redo that. If you want to redo it, and I'll consider it anew. But I mean, the more prudent course would really be to just bring him in here like tomorrow and say, and if anybody wants to come up with, he's probably been advised ad nauseum about everything at this point anyway. But given that I just said, I think some of it's incorrect, a correct advisement of here's what the issues are, here's what you potentially face. And we're going to do it in court with everybody in front of us. Y'all can have some input on what he is advised of. Does he have counsel currently? I know he's gotten rid of Mr. Melnick and Ms. Bumpus at this point.
yes, that's correct, Your Honor. Mr. Melnick withdrew representation. His father was fired, so no one has said anything to us
Okay.
about a lawyer on his part. So we are unaware of whether he has any
Okay.
representation. And I also point out just that since he is still under that immunity grant from the state, it's my position is that anything what he testifies about would not subject him to criminal exposure. We can't use it. We can't go out and.
Yeah, and I agree that with regard to the immunity, he doesn't, but it's because of the immunity. It's not because there's some statute that protects, some statute of limitation that protects him from criminal liability. It's the immunity that would protect him. And he was not exactly accurately advised as to that. I don't think, at least potentially. Okay. So, I mean, I just
Zaxby's new chicken finger tacos. One small.
like on the record, yes, if it's a yes.
On behalf of Mr. Williams, yes.
Okay.
Yes. Yes, Your Honor.
Yes, Judge, with the caveat that no party, no state, even though they say it's our witness, not have any communication with that person while he's on the witness stand, which he still is, presumably. Thank you.
Okay.
And Your Honor, with respect to Mr. Harvey's request of the court, I would openly request that the court allow us, because like we have had to transport the witness, I'd request in front of everyone that the court allow us the opportunity to continue transporting him, doing as we have been.
I mean, he's under your subpoena. Y'all are the one that needs to get him here, but no substantive conversations. Understand?
Yes.
Okay. All right. And y'all think you'll be able to achieve getting him here tomorrow?
Your Honor,
Can you get him here this afternoon? I mean, no, that's fine, but can you get him here tomorrow?
I believe that we can.
Okay.
And Your Honor, how much inquiry is the court going to allow, or examination?
We don't need to examine him about that. What we need to do, I think, is, given everybody has agreed, is just properly advise him as to
Given everybody has agreed.
what the immunity order means, what the consequences or potential consequences of refusing to testify regardless of the immunity order mean, and find out what his intention is. Okay, so I would love to get from y'all a proposal on what to advise him of. And let's let everybody kind of agree to it before we do it. And then it might not be a bad idea to have counsel for him. I don't know whether he's going to want to hire somebody, or whether he is, I mean, he's not a criminal defendant, so he probably wouldn't be entitled to counsel from the public defender's office, but maybe I can find somebody willing to take it on, whether he can pay them or not. I don't know.
So, Your Honor,
Suggestions?
Your Honor, when the court just said about compelling him to testify regardless of the immunity order, we wouldn't seek to compel it without it, because there is potential criminal exposure.
No, I know. I think you might have, I didn't mean to say that. The consequences if he does not testify despite the order. Any ideas about counsel? I mean, I think he's probably entitled to counsel if he wants it, to advise him. I don't know. Hadn't done the research on that one.
Your Honor, on behalf of Mr. Williams and I think the rest of the defendants, it seems to me most appropriate for the court to at least inquire of Mr. Copeland himself, whether he is currently represented by counsel or not, and or what his intention is if he is not.
Sure. I mean, yeah, I agree. I guess I can't find that out before he shows up here.
I can have someone just bring him in.
Okay.
Where he is, so I can actually ask.
All right. I mean, yeah, if we can find him, and even, I mean, I don't care if he shows up by Zoom for me to ask those questions, you know? I mean, that's fine with me. All right, so if he ultimately then says, yes, I'm fine with testifying, then does everybody want to start everything over, have me tell the jury, we're doing a do-over to all of it and start over with him? Or then do y'all want to agree to using some portion of what he's already testified to, some or all of what he's already testified to pre-recusal motion? I can't hear you. Y'all can think about that for a few minutes. Ms. Firstfields let me know that the 6/12 transcript, which was the last outstanding transcript of his testimony, has just been completed and is getting mailed out to y'all, emailed out to y'all. All right, so y'all think, ponder, and in the meantime, do we want to move on to the whatever motions in limine there are about Mr. Zachary? I think you said you had at least a good portion of that ready.
Yes, so counsel for Mr. Stillwell sent over a series of redactions that they like to see made, but we have objections to those, and so that is
Okay.
right here.
All right. That sounds good.
Would the court permit me to just step out?
Sure. Is Mr. Atkins going to take it from here while you're
No,
out?
I'm just asking him about Mr. Copeland and seeing if I can get him on the phone and get an answer to the court today.
Okay. All right, so the Zachary evidence, can somebody provide that to the court? Whatever we're going to be
Yes, Your Honor.
sorting through.
I'll send the transcript from this interview, Your Honor, and if the defense counsel objects, I can send what Mr. Sharp sent us so the court knows what we're
walking through.
Yes, Your Honor.
That'd be great.
Because it's broken down by numbers.
Okay, good.
And does the court already have the transcript?
I don't. No, but Mr. Atkins just said he'll send those.
And Your Honor, with respect to the transcript, they are uncorrected. There may be corrections that I make and then send to the defense.
Okay.
All right, you guys. So Woody may be coming back.
Yeah, and maybe pick up your mic.
There.
Y'all, I'm trying, I think I told y'all yesterday, I'm trying to get longer stems for these, but
I didn't even turn my mic on, so I didn't even get through step one yet. So it's now on and I am holding it. Mr. Atkins, Miss Love, Mr. Zachary's statement, his statement that I did not review yet, or I've reviewed it, but I haven't given you the total redactions. Are you planning on playing if allowed, the part where he talks to the feds about the guns?
It's possible, and there were two statements.
you should talk into the mic too, so everybody can hear you.
I keep remembering how loud I am. It is possible, and there were two. Yeah, I think yesterday when I spoke, I was expecting one more from you. There are two: the 2015, the August 2015 one, and then I think it's the March 2017 one. And we have your redaction request for the the August 2017 one. So do you mean for both of those, or are you just asking about the March 2017 one?
The transcript doesn't, I don't believe, say what date it was, but the time he talked to the federal agents after speaking to Investigator Gaither.
And so when you say put it in, I wouldn't, outside of impeaching him, I wouldn't have a need to put in all of that. I would be asking the witness on the stand about that. So I can, with the court's permission, I can break away and talk to you about exactly what it is that you're concerned about.
Okay, well, I'm gonna send over my proposed redactions for the statement to Investigator Gaither with the understanding that I didn't list out any redactions for the discussion with the federal agents.
Okay. So so you're sitting over the 2015 one? And then,
Yes.
okay.
All right, so there's one that has been done completely, the proposed redactions, right? So we'll just start on that one, and then I'm sure we'll have a morning break at some point. Y'all can maybe, if you need to huddle more on the another one, then that's fine.
Thank you.
Okay, you guys, to cover some of the dead space. So this week has been very interesting. On Monday, wait a minute, we are into Tuesday. So later last week, the attorneys learned that there was a second ex parte meeting that happened on June 7th. Before that, so June 10th was the day that they had the ex parte meeting and everything blew up in court. Well, they learned that there was a June 7th ex parte meeting where the judge was having a conversation with the attorney, the prosecuting attorneys about what he deserved, showing bias, offering to meet with them on the weekends. So there would be no court reporter there, like saying that um, the attorney that was representing Little Woody, saying that he was in coercion with the defense attorneys. Like it was just a mess and they went off. So I am going to put together like some clips, kind of like updating it because this is very interesting. The corrupt, we've talked about some of the corrupt um, in this case that has been exposed with Fulton County. So then on yesterday, they had Caleb Bumpus in court who testified to what happened in that meeting, the June 10th meeting. There was an investigator or one of the investigators who testified that there was even more conversation that happened where the court reporter was told to keep it off the record. Mm. It was bad. The, um the judge was reprimanding, Miss Love. She got into her a couple times this week. She has been doing a very partial, kind of fair hearing of everything and hearing in the evidence. They introduced the, recording of Lil Woody, so they got in that recording in the original court under Judge Glanville of his interview where he had that 9-hour interview. Well, that wasn't, according to her, according to the law, the reasons that they gave was not reason to have it played before the jury. So they're going to ask the jury to strike all of that. They went through on if they could show uh like just cause to bring it in, like lay foundation to bring it in. There were several areas that cannot even be played. So this entire trial is just kind of tainted. The attorneys were saying how broken it is. The judge still has 2 motions to dismiss the case with prejudice. They brought in more case law on why the case needs to be reduced or dismissed with prejudice. Whichever the prejudice is, that means that it can no longer be tried because there's so many broken pieces. She mentioned on yesterday that, she had said that she wasn't going to disqualify the 2 of them, Love and the other one, the prosecuting attorneys. And she made that statement, like, take it up with the bar, just because of all the bantering. But after what she heard yesterday, she is reconsidering. Um, on whether they should. I mean, it was bad. if you notice that she also said today that she wasn't sure he was ill-advised, which was one of the things that the attorneys brought up, that little Woody was ill-advised of the implications and how he could land in court. So she has so many different issues with this case, and there may be some heat coming down for Love. Fannie Willis may have to come in if they're going to keep trying it. But what she's doing, she wants to keep moving forward until she gets to those things so that if they bring the jury back and this case go forward, they're ready to start. So she's kind of tackling two ends at one time. They're getting ready to get in this script. Let's get back to the courtroom. Thank you, guys. So that is one of the court reporters that is speaking with her. She must have some questions. And on yesterday, she even had her own questions to the detective that was in that room in that ex parte meeting. But let's get back, y'all.
Ready with the first one on, that's, I guess, page 11, lines 10 through 12. Is that what that means? Or is that a timestamp?
Your Honor, that is correct. There was a couple Mr. Short had that, for the most part, I could follow. So if there's a discrepancy, I may ask Mr. Short specifically what line he wanted, but I believe for the first one, that is correct.
All right. And is this mine to keep, this teal one?
Yes, Your Honor.
I can write all over it if I want to.
You can highlight it, write it.
Okay. All right.
We are streaming from Law and Crime Network, just so everyone knows.
So, Mr. Sharp, the document that I'm looking at that says Quindarius proper session proposed edits, and it's all numbered 1 through whatever. Okay. So, where am I supposed to be looking with regard to that first one? Because it's a lot of different numbers. I'm not sure what they all mean. Okay. I assume 11, 10 through 12 means page 11, lines 10 through 12, but then it has 10 again, which I don't know what that 10 is. And then
it should be when it ends. So it would be like 10. I'm pulling up my document.
okay. It is, I'm sorry. Go ahead with what?
So that first one would be page 11, line 10 through page 12, line 10.
Okay, that makes more sense. Gotcha. All right. And is one of the objections to all of this going to be these aren't proper under the co-conspirator exception?
Well, not everything that he says in these sessions is based on what arguably a co-conspirator said to him. Some of it may be, so some objections may be it's improper character evidence, it's irrelevant, things of that nature. Right. But there is a lot of things that he was told, and quite frankly, Your Honor, there's some that I don't know him to have allegedly been present for something, and the source of his information is unclear. It may be rumor, it may be something he was told, and that is probably something that we're going to need to wade through at some point.
Okay. All right, so the very first one is, I'm about to tell you something, and I've just said I wasn't there.
Yes, in page 11, line 10.
Right. So it's obviously hearsay, so what's our exception?
Your Honor, part of it, when he's saying that he's at crucial,
No, he's saying I wasn't at crucial.
when he's saying I was not at crucial.
Right.
And he can't speak about being at crucial.
Mm-hmm.
I don't have any objection to him speaking about or trying to speak about being at crucial. I don't have any objection to taking that out.
All right, so are you good with the redaction of 11 line 10 through 12 line 10? Have you had a chance to look at these proposed redactions yet?
I looked at them. I haven't synced them up with my transcript and my
Okay.
So because I've read the transcript and listened to it so many times,
Okay.
I'm not through it with that knowledge.
Okay.
I haven't synced it up. So I don't have an objection to up to line 10. I don't have any objection to it. Page 11, line 10.
All right, so that's out by agreement. All right, so that one's out by agreement. Do you want to, is it, if I gave you 30 minutes, could you decide which ones you agree to? Okay. Sarah, something else anybody needs to take up before we take our morning break and let Ms. Love do that? All right. Anybody else? Nobody? Okay. All right. We're just going to take our little morning break early. So we'll be back at 10:30.
All right, you guys. So we're on our break until 10:30. I am going to take a break until 10:30 and do a little exercise, and I'll be back at 10:30. But I wanted to leave you guys with this bit. We are hoping to see Kenneth Copeland back today. The defendant attorneys, they want to ask him if
Juvederm Day is coming soon. Buy one $75 gift card, get one free for one day only. Join Allie now.
This bathroom's so musty.
Everybody dance.
I'm sorry. I'm still learning the stream thing, but they want to ask him if he felt if he felt coerced. And so although Love objected to it, the judge told her it's a very clear line, very thin line that we're treading on. And the other piece the other piece is she encouraged them to kind of get together and maybe even talk on yesterday, because if she dismisses it, there's like a lot of risk for everyone. If she dismisses it without prejudice, they can come back and retry everything. If she dismisses it with prejudice, of course, it's a win-win. And if the state attorneys get disqualified and she kicks them off this case, then there's going to be some ramifications there. So the piece about Lil Woody's testimony, are we going to keep all of it? Are we going to show some of it? Are we going to just wash it out and let that not be a testimony at all? They have the piece of his entire interrogation that was played in court in front of the jury, that should not have been played in court in front of the jury. Is the jury tainted now? Have they been on break watching all the proceedings that's been going on? Like, it has been a lot going on. Don't you guys worry. I am going to catch up on my reviews. We're going to get caught up on everything and have some fun. But I'm interested in this case. And so we are streaming from Law and Crime Network, learning some things. And I just thought it would be good to kind of keep us abreast on what's happening down there in Fulton County, y'all. So we're on break until 10:30. I will be back at 10:30. I'm going to get a workout in, get me something to drink, and I'll be back. Y'all, I'm excited to see if Woody was going to be coming back today. Hey, I have a viewer. Give your girl a like if you like what we're doing here. Hop down in the comments, ask some questions. We're on break until 10:30, but hang out, eat your lunch, be at work, just listen to court. It's going on today. Hopefully the jury will be back next week. And Judge Whitaker is still weighing the motions of the two attorneys regarding dismissing the entire case and all the right infringements that have happened. As we've learned, there were two ex parte meetings. There was an ex parte meeting on June 7th that was never disclosed to the defense attorneys. And they were supposed to know about that. So they never even disclosed that. Then they learned that there was a piece in the ex parte meeting from June 10th that was not recorded. The prosecuting attorneys asked the secretary to keep it off the record. So they don't even know what was discussed. That gives them grounds for dismissal. The judge reintroduced the topic of the motion to fire, to remove these two prosecuting attorneys off the case. She entertained that on yesterday. So we still have some hot rulings that are going to come down that she's still weighing the options on. And it's been good. She even asked questions of those witnesses yesterday. So Kayla Bumpus came in. The detective came in and answered under oath of a lot of things on yesterday. She learned that Lil Woody was ill-advised by the prosecuting attorneys. He didn't get the best advisement in his coercion, and we're looking to see if he's going to come in today and testify. Attorney Steele said, we want to ask him, did he feel coerced before we even entertain this situation? And so the judge agreed, like, hey, let's do it. So I'm enjoying this. I hope you guys are. Drop down in the comments. Let me know what you think. We're going to be back at 10:30. We have 30 minutes. So feel free to hang out, be here. I'm going to play a little music until I come back, just so we're not just in here doing nothing. And I need to update the copyright infringement piece on the video there. So I'm going to see if I can do that in the description. So let me get that updated, and then I'll be right back. Thank you for joining me. So that I can get it from here. Can I? Can I copy it? I can't. I'm gonna have to type this all over again. It's all good. All right, so I got that updated. At this time, normally people with bigger platforms will be reading comments from the comment section, but I don't have that luxury yet. And talking to the chat, I don't have that luxury yet either. But we will get there because I will be doing some more streams of this case and another case that I'm interested in. Good stuff. So hang out with me and I will be back in 28 minutes, you guys. I am going to get in a little walk, a little exercise situation going on and grab some water. So we're going to put a little music on for you. Yeah. Right there. And I'll be back. I appreciate you watching. Yay!
Building your online business? Go to Wix.com and set up your store on a single integrated platform. Add products, showcase them dynamically, and seamlessly track your inventory. Accept multiple secure payments and design your storefront down to the very last detail. Get all the tools you need. Drive more sales with customizable gift cards and flexible product subscriptions. Retain customers with a point-based loyalty program, email automations, and reach millions with sales channel integrations. Complete your setup with a personalized analytics dashboard. Make smart business decisions and shape the next phase of your business. Build, manage, and grow from one place. Go to Wix and launch your online business today.
All right, so we are back. Whew, I'm back from break, actually. And court should be coming back in 2 minutes. Or maybe 1. I'm sorry, y'all. I'm breathing hard into the stream. Whew, I just did my walk. Did a quick 20-some minute walk and then up the stairs to try to catch before we all right, the cameras are moving. So we're back. Let's hope we get little Woody up today and see what he has going on. Whew. I'm sorry. Bear with me, y'all. I wish I can stop that from happening. Delete. All right, I'm just gonna create a copyright banner down here to kind of protect this stream while we're waiting. Make sure that I'm still up on the stage. I am. We still got that going. Okay. Hey, welcome back. We are just waiting for court to resume. They're supposed to be on break for 30 minutes. I am updating the copyright banner down here to cover this stream. So just to catch you up, I thank you for coming in. Just to catch you up. So the attorneys are still we're on day 5 of them updating, getting Judge Whitaker up to speed on what's been going on with the case. And so on Friday, we learned that there was another ex parte meeting that happened on June 7th that included, someone just ran across the thing, that included commentating of just the judge,
Agreement on
the
anything?
attorneys? Okay.
Judge, I have just been reviewing Mr. Sharp's proposed redactions, and there are some that I agree to.
Okay.
Not a whole lot, but he's already given the court the first one. Does the court have a copy of his redaction?
Yeah, the proposed redaction, yes.
Okay, so looking at Mr. Sharp's chart, number one, we've already discussed. Number 17 is the next one.
All right. And that's agreed to?
Yes, I don't have any problem with that. That's the discussion of the search of the defendant Williams' home, revealing a gun, and the gun and the contents of that search were suppressed, so that should
Okay.
not come in.
All
As well as number 19, which is on page 73 of the transcript.
right. All right.
That is, just to call it out, speculation.
Okay.
Specifically, it's 67, line 15 through 19. No, I'm sorry. Mr. Sharp has a description that is different than the lines that are listed. So 70, so on page 73,
Mm-hmm.
I don't have any objection to lines 10. He has it right, lines 10 through 13, no objection.
Could you just give me the number of the section you have to
17.
So 17 and 19, I also don't have any objection to. 23, I don't have any objection to.
Okay.
Could you clarify what the first one you did not have an objection to?
The first one that I did not have an objection to was number 1. And number 1, if you have, you already have the redactions? Okay, so it was Mr. Zachary, after saying he wasn't at Club Crucial, he talks about what happened at Club Crucial. And Your Honor, I will say that as it stands, I'm not trying to get that in. I don't know if something else changes, but right now I agree that it should come out.
Okay. All right. So we had gone through 23.
24, 25, 26, I don't agree with. Going to 27, it is 9211. Keep out. All the way through 9422. Mm-hmm. 9211 through 9422. That's what I've gotten to agree to. If the court permits me to further review the rest of them, because some of them I was looking and I don't agree to, I'm ready to argue those, or I can.
Let's do that right now. And then over the lunch break, you can go through the ones you hadn't hit yet and see whether there's agreement on any of those.
Did
Okay?
Did the state agree to 27 or no?
It's,
No, we
no,
stopped.
sounds like so far just 1, 17, 19, and 23. Okay. All right, so I guess that means 2 through 16, we need to take up.
Yes.
Okay.
And Your Honor, will we just follow the same pattern we did last time where the defense tells what their objection is?
Yeah, so I mean, the objections are essentially on the proposed redaction, so I guess the objections generally speculation about why they shot up a house.
So page 13, line 16 starts at Dennis talking with the witness about the house getting shot up. And this is following, I think you have to go back a little bit further to page 12 to get better context. In that conversation, the witness is talking with Demikion Garlington about people that call him that night, starting on page 12, line 14. And Quindarius Zachary is talking about his girlfriend telling him what's going on.
Right. Yeah, so it starts at 13, line 16. He doesn't have objection to him saying, hey, this house got shut up. It's why the house got shut up, which the objection's speculation.
So my argument, assuming I established the proper foundation, is that with Quindarius Zachary saying that Trevante was helping D-Fight. He's talking about Demikion Garlington.
Right, so what would his basis of knowledge be? You would need to establish that he's got a legitimate basis to know that.
That's the point that I'm making. Like, without doing it, I wouldn't, if
Okay.
I were not able to do it, I wouldn't proffer it or even try to play
Okay,
it.
and so you think you can?
Yes, that's the point. Especially, Your Honor, when we're talking about, he goes all the way through to line 2.
Right, 14, line 2.
Okay, I was looking at line 14.
And
unless if I don't establish that foundation, I won't tender that. But if I do, I just want to be able to play that part about his.
Okay, so how about this? Right now, it's out on the, granted as to speculation.
Okay.
And if you establish it,
Okay.
then that'll be a different story.
That'll work. Okay, so the next one being page 25. So 25, page 25, line 9 through 25:12 is a direct statement from the witness about an incident that's listed as an overt act on the indictment.
Okay,
And what they were doing, it's an admission.
all right.
It's an admission against it.
All right, so what's our objection there, Mr. Short?
My objection is drug use. And the character that's associated with that, and the statement, they didn't, where is it? They really didn't care. That's speculation about someone else's mind state, or state of mind. The reality is, within this context is a story about that Mr. Zachary gives, that he describes.
Here's the thing, aging begins in your cells. Start supporting your cell.
I am objecting, so I'm not objecting to him talking about that at this time, but I am objecting to him pontificating about my client's state of mind as this was going on, because he can't really speak to that.
So that would just go to the, they really didn't care part. And then you're saying the fact that he's saying they were taking Xanax is.
I don't know his basis of knowledge of that, but I don't believe that to be true, but I don't know his basis of knowledge of that.
All right, Ms. Love.
So Judge, my argument right now until I speak to him is that he is in the car with the persons that he's speaking to the detectives about. He has the opportunity to observe them up close. The question posed, as the court can see, is did they feel some kind of way that you didn't get out of the car? We believe that the evidence has shown and will continue to show that these people he's in the car with that are shooting up these houses are his friends. He's known them for a long time, and his personal observations of them and personal knowledge of them is what allows him to make the assertion that he does, that as to why they didn't care that he didn't get out of the car while they're facing arguably danger. They're the ones getting out, according to Mr. Zachary, doing the shooting, but they were high, essentially. So that's the reason why they didn't mind him not getting out of the car. We'd argue that it's intrinsic. It could go to why they would be so brazen as to do something like that. But the fact that they were high while they were shooting, the fact that it incidentally touches on someone's character.
Okay, so I don't have I don't think I'm going to overrule it as to character. And if you can establish that he actually knew they were on Xanax and high, that's fine. On the they really didn't care part, are you maintaining that part should come in?
Yes.
Because his observation is that
they didn't mind. He's offering up an explanation as to why. Basically, the investigator's a little bit incredulous that, wait, you.
Right. What's the motive? The motive's just they were hot.
Yes.
All right. Well, if you can establish that he knows that they were on Xanax, then I will let you use that part. So overrule this to character and sort of like to be determined as to the basis of knowledge on whether they were high or not.
I put subject to foundation.
Okay.
Baby. I do hope this goes to trial, y'all, because I just want to see them be able to lay foundation to get this stuff.
The next one is further down. Mr. Zachary is asked by the prosecutor, what was you all's intention when you all headed over there? He says that we were going to kill one of the boys. And then the prosecutor says, and one of the boys, I know we talked about a bunch of names, but which of the guys were you looking for? And then Mr. Zachary responds, the request is to take out 17 through 25, all the way
Yeah, I think just
I'm sorry,
17 through
25.
17 through 20.
Yes, I'm sorry. So 17 through 20,
Right.
he's specifically talking about their intentions when they went on this shooting spree. I think that it's not only relevant, intrinsic, it tells, it gives a motive for what they were doing. He has personal knowledge of it. He was in the car. They were riding together.
Okay, well, as long as you establish that he knew that's what they were planning to do, and it's not.
And he doesn't say they, he says that
Oh,
we
he's-
were going to kill one of the.
Oh, I'm sorry. Actually, I maybe need to put on my glasses. Thought that said they were, but that we were, yes.
So, Your Honor, let me just back up. So this is an incident where houses were shot up. Mr. Zachary was charged, and in this proffer session, he's given testimony to try to get himself a deal. And I understand that's subject for cross-examination. My client was never charged.
Okay.
Mr. Zachary is throwing my client's name into this. And I understand that's subject for cross-examination as well. But when he says, what was y'all's intention? Now, it strikes me that Mr. Zachary can speak to his own intention, unless he says, Mr. Stillwell was there, and this is what Mr. Stillwell said, or something of that nature. He can speak to his own intention, what his intention was, and the state can ask him on the stand, Mr. Zachary, when you went over to the house, what was your plan? But unless someone else articulated their plan to Mr. Zachary, I don't think he's authorized to speak to what anyone else's plan was or intention was. And when he starts saying, and it's not his fault because
of the way
Mr.
it's
Bailey
asked.
inartfully asked, what was y'all's intention? And that prompted him to speak for other people.
Well, I understand, and it may very well be that you can establish that they all had a joint intention because they had had some sort of talk about it beforehand. Or
And they actually he reveals earlier in the interview that they do discuss it.
all right, so where's that?
So up. On line 4, he says, because he said, we don't want to shoot a house, be that to them. So on line 2, Investigator Dennis asks, why does Muntung, and that is actually Antonio Sledge, it's spelled wrong, tell you not to get out of the car? He said, Mr. Zachary said, because he said, we don't shoot up houses, leave that to them. That's one point that they're talking. Further back on line, page 24, when Mr. Zachary is talking to Detective Dennis about the kind of guns that they have, he's naming them.
Okay, I mean, it does look like they kind of had.
Well, Your Honor, he's talking about what Muntung said. Muntung's not even here. My client is not Muntung. And so I don't find respectfully what Ms. Love said to really address the issue.
All right, so where is it that your client gets, what is it that is indicating that he's talking, his speech includes your client if your client's not in the car?
No, my client is supposedly in the car according to Mr. Zachary. But what Ms. Love talked about is Muntung telling Mr. Zachary to not get out the car, saying, we don't shoot up houses, leave that to them. What that has to do with my client's intent to kill someone, I'm not seeing that link at all. And my whole point is this, Your Honor, if they can establish that that through Mr. Zachary, that my client indicated what the intent was, what the plan was, that's not in this transcript. That's going to come across through live testimony, which would render these prior statements, out-of-court statements, irrelevant anyways, because it would have been established through live testimony.
Right.
So I don't know why we would keep this in the transcript.
Judge, I thought that the whole purpose of this exercise was assuming that they don't.
It is. Okay, so assuming you need to use it as a prior inconsistent state that.
Yes, and in response to Mr. Sharp, Mr. Zachary is talking about his own intent and his understanding of what the conspiracy was. Arguably, this is a conspiratorial act of going out to shoot. We were going to kill one of the boys. So he does not, I don't think that it's improper for him to be able to talk about what the intentions of the group that he is acting as a part of were, as shown by their actions and their words throughout the course of the conspiracy itself.
But if his statement is just based on assumptions he's making through the actions of others, then the jurors are in a similar place as Mr. Zachary to make that, to draw that conclusion.
But Mr.
So
Zachary,
I don't understand why Mr. Zachary, his conclusion about what my client's intent was would be particularly helpful or relevant to anything unless my client articulated it to him. And from my understanding of what Mr. Zachary's saying is he gets a call from his girlfriend Summer. Mr. Garlington and Mr. Sledge leave the club. Mr. Zachary doesn't know, according to his story, he doesn't know how Mr. Stillwell gets in the car because he wasn't at the club. And then they pick up Zachary last. And Zachary does not describe any conversation in the car on the way to these houses or anything like that. He doesn't give any context about communication. He's just kind of like, I got in the car and this is where we went.
so Judge, this is also the third interview that Mr. Zachary gave. He gave one earlier in 2015. This one occurred in 2017. So there are statements about this same incident in the 2015 interview as well. So we haven't gone through that one, but I could cross-reference that as well and provide those cross-references to the court. But the reality is that an assertion by a co-conspirator, if everyone is acting towards the same goal and people are getting shot up, houses are getting shot up, and
With assault rifles that are in the car.
right.
Yeah, I'm gonna overrule that. All right,
25.
28, line 17.
The
No.
font is a little small. I'm just having,
I'm sorry?
I need the court's glasses. I'm
Yeah,
just trying to
28,
get down.
line 1 through 3.
And with this one, Your Honor, I'm not trying to mislead anyone. If one of my colleagues tells me I'm wrong, then I'm wrong. My recollection, there has been no testimony about someone being shot in these houses.
Okay.
If I'm wrong about that, feel free to correct in this instance. The
So
shooting of
this
the houses.
one, we have given the list of 30 witnesses, and one of the first witnesses after Mr. Zachary is the young lady who lives at this house and her sister
Okay.
getting shot at. So there hasn't been.
Did somebody get shot at this house?
Yes.
And that evidence will come in through this other, what's the name of that witness?
Miss Bell and her sister Cecilia.
So they're coming to testify?
I see them on the witness list.
You don't see them?
Yeah, I do. I see Denise Bell. I don't know what the other person's name is. So you intend to call somebody who says somebody at this house got shot? Okay, so then that is all right. All right, number 6. And I guess let's make this 3-page proffer of proposed edits, a record of part of an exhibit to today's proceedings. So in the event of an eventual review, whomever is reviewing it will know what we're talking about when we say on to number 6.
Can we make, you don't want us to use the one we're writing on, you want to make
Yeah,
it,
I mean, just a
easier.
clean copy.
Okay.
Yeah, I know we're all writing on ours right now. So yeah, just a clean copy, and it can be,
We can do that.
I don't care who makes it an exhibit.
Okay.
It's basically just for purposes of the record. I can make it a court's exhibit to today, court's exhibit 1. I'll print out a clean copy right now. All right.
So the next one is page 29, line 10 through 29, line 11. So going back, Your Honor, you can see from page 28, line you can go back up as far as line 7, but you'll see that there's context. You want to pause?
No.
Okay, you can see that there's context. Mr. Zachary is talking about where they went, what they did. And at line 18, he's talking about the house on Oak. And later on, you have Investigator Dennis talking about his familiarity with the house.
Right.
The fact that he offers a concrete fact, his knowledge about the house, and Mr. Zachary doesn't correct him or doesn't say anything about it, I would argue it just
How would
goes
he
to the
correct him
effect.
to that?
I mean, it's not something that by itself is very material. There's just,
Then take it
I don't,
out. Strike it. Granted.
you're, okay.
All right. I'm just writing August 6th, 2024, Courts Exhibit 1, as to this 3-page
Yes, Your Honor.
proposed redactions. Okay.
So the number 7 is page 33, line 1 through 35, line 14. That actually starts back up on page 32, or actually 31, where Mr. Zachary is talking about Trevante. So page 31, line 16, where Dennis says, got it, you were sitting behind Munktunk, Demikian is in the back with you and Shannon is in the front, and then and then Mr. Zachary says they were in another car, yeah. And they go on and talk about that. My argument is that the portion that they're asking to keep out is all information Dennis is exchanging with Quindarius Zachary about activities that YSL and Rivals are sort of involved in. Mr. Dennis talks about how they thought it was Kale, and Mr. Zachary says, no, he corrects him, no, and then Dennis says, well, enlighten me, and he's like, no, you go ahead. But Zachary later on line 17 says, they tried to say that we did it, acknowledging that there is a we, acknowledging in a way that helps to prove count 1 in our indictment. There is a they who is an opposition group who tried to say that we did it, we being YSL.
Where is the part where the opposition group is saying they thought we did it? I see the investigator saying, we thought y'all did it, but.
No, line 17, where he says they
Oh.
tried to say that we did it, on on page 33.
Oh, it's back on page 35. I'm sorry. Okay. Okay. And so this would be to establish.
The existence of the enterprise, the gang, and the fact that there is an opposition and a they and a we.
All right, Mr.
So,
Sharp.
I mean, that's not factually accurate.
Okay.
On this.
Pull
alleged-
your mic towards you, if you don't mind.
On this
It
alleged.
moves, so you can just move it up on your desk, maybe. I don't know.
with
I
this-
know, they're all annoying. They get in the way.
With this alleged incident, the shooting up the houses, Mr. Zachary also puts a gentleman, two gentlemen, a Trevante Turner and a Tay, as being in the caravan with them shooting up these houses. Trevante Turner is sadly deceased. He has never been, I've never heard anyone allege that he was a member of YSL. The paper just reported that he was associated with, I believe it was If Gang.
I'm
but
not sure I'm gonna go on what the paper says.
I understand, but the state has never alleged that. He's not charged in this.
Okay.
This is a gentleman who, has not, there's been no allegations that he's been affiliated with us. I believe that there's a suggestion that he's a friend of Kenneth Copeland's, but that's it. So I don't want it to come in, but I don't have a legal argument at this point against them. Mr. Zachary saying Trevante Turner was part of this mission that he's claiming existed. But at the times that I highlighted that I have a problem with, it's talking about a wholly unrelated incident where Trevante Turner, who's not one of us, and Shell Kell, who is Kelvin Watts, were having their own side beef and shooting at each other. And I believe Trevante was shot maybe by Shell Kell. Mr. Watts was maybe shot by Trevante, but it has nothing to do with this indictment. It's not alleged as an overt act, and it has nothing to do with, if I were to, for the purpose of this argument, agree that there's a group called YSL and it's a criminal street gang, which obviously is an issue here, this incident would have nothing to do with that. And it's just talking about, and they're just really treating it as small talk. That he's telling a story and then it's a little aside about Trevante, which has nothing to do with this case.
All right, Ms. Lett, what do you have to say about that?
We had served in discovery a PowerPoint that involves, just as it relates to the assertion by Mr. Sharp that Trevante Turner was not associated with YSL. And in that PowerPoint that we served, we reflect on one of the slides at January 27 of 2015 incident 15-026-2801 on Stanhope Circle, where shots were fired, specifically where Trevante Turner was shot. And it's listed that he is an associate of YSL/30D. Just to go to the assertion that there's never been any indication about Trevante Turner being YSL.
Well,
but
an
that's,
associate of YSL and a member of YSL aren't the same thing.
they aren't, but I'm not asserting one way or the other as it relates to associate or member with respect to Trevante Turner. What I'm saying is that in saying that they tried to say we did it, Quindarius Zachary, when we charge the gang act, associate or member, it doesn't matter. associates commit acts with the gang. So it doesn't in any way cut against, is my position, my argument that in saying they try to say we did it, he's not just talking about
All right, let me.
So if gang is the gang that
So
they're
is that the they here? This is the
associates
part of the gang that
yes.
there's the alleged beef back and forth and the
Yes.
series of shooting, the members that are involved in this little, even if it's a side incident, are all that gang?
Yes.
Okay.
Well, if that's the money line, they tried to say, like, how's that admissible? They tried to say we did it. I mean, false accusations by an unnamed group about something that the declarant, in this case, Mr. Zachary, is actually saying they were wrong about. How's that admissible to anything? And if that's the key section, that's inadmissible in itself. But I think this whole section is just wholly irrelevant, and it confuses the issues.
And if the court goes on further down, and investigator Dennis elaborates, that basically you all were laying in wait for Kelvin Watts. It says Watch, but it's Watts, W-A-T-T-S, Shell, who also has a gray Charger. Just in the continued conversation with everything he asserts, he is making an affirmation about the existence of the gang itself. Yeah, that's what they say, is what Quindarius Zachary says. He's not pushing back against the notion that they would be laying in watch for Shell. He's just saying, yeah, that's what they say. There's an acknowledgement still of an opposition and a group that he belongs to.
All right.
He's literally saying, no, that didn't happen.
Right. But she's not offering it for whether it happened the way they said it happened or not. She's offering it for the concept that Mr. Zachary is saying, yeah, there's this we here that is YSL, and that is certainly relevant to the issues in this case. And if you want some kind, I mean, if it even comes in, because I assume, this is all if he doesn't testify as the state thinks he will, and then they have to impeach him, although, it would be interesting to see how you use this and what you would be using this to impeach for. Because if your purpose with it is to establish there's a we and a they, then he'd have to testify inconsistently to that for you to be able to use this. Do you understand?
Yes.
Okay.
And Your Honor,
and if that is what you're able to then use it for, I mean, I'd be happy to limit that this is only for the purpose of that, and it's not for whatever may or may not have happened with regard to some side shooting incident.
And let me just say that in his statements, Mr. Zachary, in his statements, and if he testified, I anticipate, he doesn't deny that there's a group called YSL.
Right.
He doesn't deny any of this. So I don't think that these issues are really.
Yeah, that's what I'm saying is this one may be one that never materializes, because I would say this is potentially admissible as impeachment on the issue that you're saying you want it for, not anything as to whatever this actual shooting is. Understand?
yes, and
Okay.
my understanding about the exercise overall is just to identify those portions that just absolutely cannot come in.
Right. So I don't want you up here saying, so, hey, tell me about this time that, you and whomever were involved in this shooting with the, and whatever it is.
So unless, right, I understand fully, like,
Then
in
he
other
says
words, don't
something
try to
different, you're
get
like,
him, don't try to impeach him just to get in some ancillary, otherwise inadmissible thing.
Correct.
Yes.
Okay. All right, moving on.
Number 8 being page 36. Lines 1 through 30.
I'm sorry, I haven't read it all, but if it is gang members being happy because Gaither's not working anymore, how's that relevant?
So, Your Honor,
Yes.
I would argue. But I can concede that and say that there's really not, I can let that one go. I can stipulate to that.
Okay.
I just like it.
And, Your Honor,
And
I think I may have made an error on that. 36, 1 to 24 is certainly about that. I'm not certain 37, 8 to 18 is about that same thing.
Okay.
I thought we were just doing the 1 through 24 first.
Yeah, all right. Well, I mean, he's got it all as number 8, so,
Okay.
all right, so agreed that 36, that part is out. So turn into 37, 8 through 18.
So in 37, 8 to 18, as I understand it, they're trying to identify Tay, and they're showing picture of Tay with a car, and they're saying, is that the car? And then Investigator Underwood and Dennis and Zachary are agreeing, no, that's not the car. That's the car that got shot up by another person named Kel. It's just about Tay's other car that was not involved in the April 28th, 2015 shooting up houses being shot up. It's just
Okay.
talk about another car being shot
All
up.
right, is
Has
that
nothing to do-
relevant?
So, Judge, in context 37, Mr. Sharp's objection goes all the way into page 38, unless I'm reading it wrong.
No, it's 37, 8 to 18, right?
Correct.
Okay. For now, Judge, I can stipulate to that. I don't see any reason to keep that part in right now.
All right, so that is also out by agreement.
All right.
And Your Honor, should anything, and I don't anticipate it, but should anything come up that causes me to ask the court, hey, there's something I agreed to that I need to get in now because
Let's
this
not wait
happened.
till the last minute to do it. Okay.
It would only be by virtue of something happening on the stand.
Okay. I mean, can you imagine a scenario why it suddenly becomes relevant that some other car that
It's not the car being shot up, it's Mr. Zachary giving the description of the individuals and his knowledge of certain individuals.
Tay?
Mhm. And
Okay, so
and
that's
boy called
lines
KL.
3 and 4. Is that Tay? Yeah.
And 16, where he's talking about the other boy called Kale. Those sort of instances. I don't foresee them being necessary, but I didn't want to not say to the court, hey, this might come up.
Okay, well, so maybe if there's some issue as to who Kel is. Okay.
And then I think that the next one on number 8 is all of page 38.
Yeah.
It's 38, line 8 to 39, line 11.
Hold on. 38. Line 8.
Okay.
Through 39, 11.
Really to 39. It's
Through 39, line 1.
the end of 39.
Okay.
Oh,
It's two different incidents. It's a discussion about people saying on the street. Again, I'm just trying to clean up this transcript. It's just going to be confusing to people. I don't care if all sorts of bad things come up in against about Tay one way or another.
Right.
But I'm just trying to limit confusion that
Right.
the jurors would have. And they're talking about people on the street saying that Tay shot up Rich Homie Kwan's dad's barber shop. Rich Homie Kwan's
I have no
father
objection
is a
to-
barber and runs a barber shop.
All right. She may agree.
I have no objection to 8 through with the clarification that he made, because I thought it was the whole page.
Okay.
So I have no objection to 8 through 24
Okay.
of
So,
page 38.
all right.
And then on 39, uh, 30 to 39:19, 1 to
39.
19.
39, 1.
39, 9 through 19, or
1
just
through
all
19.
one? Okay.
I have no objection to 1 through 13, where he stops at,
Okay, so 13 is the end of the Rich Homie Kwan
right,
barber shop. And then
yes.
they start talking about Tay shot Kel.
And
I don't represent Tay. Tay's not associated. So, but it's just I just think it would be confusing.
Why is it?
Tay is associated, that's what we were just talking about, Tay being Trevante.
Right. Who's dead and not on trial here, right?
That's true, unfortunately.
Okay. So is it relevant?
In it,
Get a judge.
I mean, I would assume you want
No.
a clean, clear story to the extent you can have one as well. So is this relevant to the story the state is attempting to tell?
yes, it goes over into page 40. There's a video that we're gonna have about with Quindaria Zachary, Antonio Sledge, I think Demekion Garlington, and they're saying they're talking to Shell Kell, who is If Gang, and I think that they have a gun. That's my memory, that they have a long gun, and they're saying we ain't going back and forth, and they're saying disparaging things. And it's over a girl named Antrevia Smith. And when the court sees Tree in this transcript, they're talking about Antrevia.
Okay.
So to the extent that we're talking about one associate or member of YSL, Trevante, and we're going on into the fact that Antonio Sledge and Shell Kell were seeing Antrevia. We're getting into information that we've noticed the defense that we're gonna introduce anyway. So I don't know why this would not.
I don't know or understand the nexus between Mr. Sledge threatening Kel on social media over a common girlfriend and Tay shooting Kel. I mean, I'm not talking bad about the guy. I think there was probably a lot of people that had problems with Mr. Kelvin Watts, and
We'll take it out.
Tay shooting.
All right, they'll take it out.
We'll take out. So it's gonna be 15 through 21.
All right, so we already agreed to 39, 1 through 13. So I think this would start at 14. 39, 14 through what?
14 through 21.
I have 4215. It bleeds into number 9. I think that's why I was unclear. I made it its own separate one, this issue.
Wait, what? Now?
To number 9 on my list is the continued discussion about the beef between Kel and Trevante, and they start out with Trevante shooting Kel, and then they talk about how Kel allegedly shot up Trevia's house. Again, something that I don't believe that the police believe is true. That was Mr. Zachary.
We don't.
Saying his understanding was that Kel shot up his girlfriend Trevia's house.
All right. Hang on. Ms.
So-
Lev.
In as much as Mr. Sharp said that the police don't rather believe that Mr. Zachary's line about Kelvin Watts shooting up Entrevia's house, that part is correct because Entrevia Smith relayed to police when she gave them that video that Kelvin Watts was in the house with her. So in as much as Quindarius Zachary is attempting to push responsibility from what we believe is one member of his group to a member of the opposition group, I would think that would be relevant. It wouldn't be the first thing that I would ask him. It's something that I don't think is inadmissible, but it's also something that at this time, we're going to talk to him. We've noticed the defense about our intent to talk about when Entrevia Smith's house got shot up.
Mm-hmm.
It's just not every line of this portion that Mr. Sharp has labeled number 9. We may not get into every single line there, but the topic itself is what we did notice them that we're going to introduce evidence of.
If they bring up shooting of Trevia's house, that's one thing, and that's, it may or may not be relevant. But my issue, and I don't agree with the state's characterization about Mr. Zachary lying about it. What we're dealing with here is not Mr. Zachary lying. Mr. Zachary wasn't at Trevia Smith's house. Mr. Zachary was not shooting at Trevia Smith's house or being shot at Miss Smith's house, Trevia Smith's house. Mr. Zachary is passing on rumors that he's heard through the grapevine about who did what, and the police are saying, well, we don't believe that's accurate because we believe that Shell Kel was in the house. So how could he shoot up the house? So it's whether it's a relevant topic or not, it's all based on hearsay that Mr. Zachary has no firsthand knowledge of.
Excuse, Judge, I just point the court's attention to the first line of page 41. And I'd also point out that Mr. Zachary was in that video that Entrevia gave over to the police after her house got shot up. He was in the video along with Antonio Sledge, where they were threatening Kelvin Watts.
All right. Let me ask you this. Could you take a closer look at the rest of 39 through 42 and maybe sort out what part of that you think, if he doesn't testify as you think he will, you would use to impeach him on a relevant issue? And then maybe
I'll be
get
right
back
back,
to
you guys.
us on this one?
Yes.
Okay. Because I mean, I kind of hear you saying, even you think not all of it is anything you would want or need. Okay.
And that's all the way through 42.
All right. So.
I hope you guys don't hear me eating.
The
I'm
next one is
like my
number
bad.
10 is 42. line 17 through 44, line 6. So when the objection is lack of personal knowledge, I am laboring under the assumption that Mr. Sharp's belief is that Mr. Zachary lacks personal knowledge. I would just ask that the court allow it, because it's all opposition actions towards one another. Shell Kell shot up the gambling house. On McDonald Boulevard, Dennis asks on page 43, line 1, that's when Thug's car got shot, right? I believe, if we haven't already, I believe that we have we've touched on that there was a shooting where his car got shot. But it may have been with Kenneth Copeland and some of the stuff that we have to redo.
Right.
But Mr. Zachary is saying, yeah, shot up Thug's car. Thug wasn't studying it. All of that information, maybe not like that, but that information we anticipate bringing out. So to the extent that Mr. Sharp objects and has as his basis lack of personal knowledge, I would just ask that the court find that it's admissible subject to the proper foundation being laid for it.
I'm okay. That seems reasonable if you can lay the foundation.
Okay.
Yes.
Okay. Okay. After consulting with others, we're going to withdraw our objection.
Okay. All right.
All right. So I'm gonna take that out.
All right, number 11.
45.
That should,
15.
number 11 should be 46,
Okay.
line 15.
Okay.
46, 15 through 16.
Yes. Well, maybe I'm wrong. I'm wrong. It was supposed to be 45. I'm sorry. They're all talking about an unrelated, they're talking about a girl named Clenethia Rant. And then Mr. Zachary just says she's dead. And then they talk about the circumstances of her
Okay.
murder.
I don't have
All
any
right, that she
objections to that
agrees.
part coming out.
Okay.
What's her name?
So that's
That's 45, 15 through 46,
Yeah.
16. I agree.
That's so sad. These young girls are getting caught up in this stuff too. Losing their lives.
Okay, let me interrupt y'all a minute. I have word that Mr. Copeland is here and available right now. so I'm
Oh,
gonna pause
Copeland
what
is
we're doing
coming
with
in.
this And
Lil Woody.
have him in, see if he has an attorney, see if he wants an attorney. We don't yet have anything put together that I'm going to advise him of, but
I'm good with that.
we could get through a little bit more of this, tell him to hold tight, take a lunch break where y'all can come up with something. But I could at least find out about the attorney issue right now. Okay. Hi, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters.
Huh?
I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I never wanted to testify.
Okay, the first, well, right, want to is maybe the wrong term, but my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney? I would think that would be a no then, if you don't know.
I'm saying I was talking to Melnick, but.
Melnick?
Yes.
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay. Does anybody know whether that actually occurred?
I don't believe it occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in.
she was standing and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
Yeah, I know
don't-
she was.
There
but-
was nothing about Mr. Melnick to my knowledge.
Okay, maybe
There was, Miss Bumpus actually said yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his,
well,
he could do
choose
one
not to
thing,
testify.
right? Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case,
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity, understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So if
do
I
that
don't
over.
testify, so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial, but I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
here? To the end of this trial,
Yes.
not the other people.
Not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you. So, I don't know who. Okay, my litigation manager is going to reach out to Mr. Melnick, see if he can get a hold of, see if she can get a hold of Mr. Melnick and find out what his availability is. And depending upon his availability, we'll
Looking out for him.
just
Trying to
see
be.
when it is that we have Mr. Copeland back.
This is good.
Because I want him to have the benefit of counsel. And then I also want y'all over the lunch break to work on whatever you think ought to be the correct advice to him. And if you, the state, believe that it is possible to hold him past the trial for which he is under subpoena, then you show me what authority
Yes, Your Honor.
lets you believe that. Okay.
Your
All
Honor,
right. Yeah.
One thing, I think that the transcript reflects this from June 10th, and as well as Ms. Bumpus's testimony yesterday. She was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said.
No, what he said was, if you plead the fifth, I'm not representing you. So I don't know, what that means. I'm just going to reach out to Mr. Melnick, and at least Mr. Copeland thinks Mr. Melnick is still representing him. And if Mr. Copeland never signed whatever that was relieving him, I don't know exactly what their arrangement is, but let's find out from Mr. Melnick.
Yes, Your Honor.
All right. Okay, so let's get a few more minutes in of this before we break, because it's not even noon yet, and we were making some progress, which is good. All right, so we were on number 12.
It was, and that's exactly right.
Number 12 being page 47, lines, if I'm reading correctly, line 14 through page 50, line 8.
Yes.
Okay. So, Your Honor, the objection to this portion of it, just to give you a little bit of background. So, this fight happened around January the 6th, and it did begin with Mr. Copeland, according to the reports from our investigators, but it involved more than one member of YSL, more than one alleged member of YSL. Mr. Bloody J, who is a member of If Gang, was on the other side of the fight from YSL, and other people who are in the courtroom now participated in that with them. So Mr. Zachary's rendition of what happened, we would argue it's Mr. Zachary's knowledge of and participation in this gang is what allows him to be able to tell this to Detective Dennis. Mr. Shart's assertion, it does not appear that he was there, I don't think is a ground to exclude it, assuming that the court is satisfied with the foundation that the state lays for Mr. Zachary's
being
ability
a
to
co-conspirator.
Yes, we would argue that it's admissible. It's
So do you know whether he was there or not?
So
let me ask Mr. Shart, is the basis for you saying you don't think he was there that no on line 23 when Is that the basis of it?
What page, line 23?
47, line 23? Because I don't think that no is actually an answer
Oh,
to.
no,
Okay.
it's not based on that.
Okay.
You
have no reason to believe.
No.
Okay.
I actually do not know
Okay.
he was there, and I haven't heard anyone talk about him being there.
Okay. Do we
And
know whether
and
he
this
was
is-
there?
Page 48, line 5. Start at line.
Oh, so we went back there. Yeah.
Okay,
Okay.
if he was in fact there, then.
And then
I would
somewhere
draw-
else, he says, Woody, okay, all right, well then you'll withdraw that objection?
If he was there, then yes.
Okay. So that number 12 is withdrawn. All right, number 13.
My understanding is this is page 54, line 18, through page 55, line 11.
Yeah, let's take that up first.
So the state has no objection to page 54, lines 18 through 22, where investigator Dennis says, who they say killed him, meaning Donovan Thomas. Zachary repeats the question. Ultimately, Zachary says, should they say Woody and them? I don't know for a fact. So I would agree and argue that you don't know.
Okay.
So it's
He's
not.
telling them,
Okay, so 54, line 18 through 22, you concede should be redacted.
so, and let me also give further clarification. Mr. Zachary, later, he tells earlier in 2015, he relays to law enforcement about statements made to him by 2 people in the courtroom now. And 2 people admitting having killed Donovan Thomas.
Okay.
This statement right here is after 2 years later. So, when he says, they say Woody and them, I don't know for a fact. If somebody argued that that's an inconsistent statement that should come in, I'm not objecting to it coming out because what I feel is a lie is irrelevant, but I'm not objecting to it coming out.
Okay.
So, Your Honor, we got a lot of moving parts here. Because eventually, I agree with Ms. Love. Eventually in this statement, Mr. Zachary claims that Mr. Kendrick told him that they killed Nutt and Mr. Stillwell told him that they killed Mr. Thomas.
Okay.
So I anticipate, because, I was doing this for Mr. Stillwell, but I anticipate other counsel in this courtroom arguing that are affected by this, arguing that this is spilling the beans and it's not a statement by a co-conspirator and therefore not admissible. Oh, okay.
I think.
Okay. So, right. Okay.
Okay.
So if I guess I'll rewind. I will say that if there is testimony, either through direct testimony or cross-examine or impeachment, that my client said something to Mr. Zachary, or that Mr. Kendrick said something to Mr. Zachary, then I would want to get that in.
18 through 22.
Right, because it would be inconsistent with the claims he says later on. Here he's saying, well, they're saying Woody and other people,
All right,
but
I
then
don't know.
later on he says, my client directly said this.
All right,
So if that comes in, I'd want to use that for impeachment.
I'd have to know who the they is here. right? Before that could be, if the they is Mr. Kendrick or Mr. Stillwell, yes. But if the they is some random amorphous gossip rag,
Well,
no.
it would be relevant because if he's telling the truth, okay, assuming he's telling the truth.
Oh, I see I see what you mean. If he's already said, or he will later say.
He's going to say that he already said in a different statement, and later in this statement, he's going to say that my client told him at night. And if he's holding that information, then him answering, they saying Woody and them, I don't know.
All right, I still need to find out who the they is then, because the question posed by the investigator is who they say killed him,
I think
right? So
who the streets are saying.
okay, well then, for Mr. Zachary to say, here's what the street is saying, is not inconsistent with, but I actually know because the perpetrator told me it's the perpetrator. So that would not be this 18 through 22 would not be inconsistent to a statement by Zachary that Mr. Kendrick and or Mr. Stillwell told me personally that they're the ones that did it. You see what I mean?
I see what you mean. I would argue that that would be the time a reasonable person would say, who they say did it. Well, if my client had said he did it, say, well, I don't even need to tell you who they say.
All right, well, I would reject that argument. So that's out. All right, so next. Is what, 20, page 54, line 23 through 5511. Is that all going to be the same
That is all.
chunk of whatever? Okay.
So we're starting at page 57, line 22.
No, 54. Because all we dealt with was 54, 18 through 22. It goes all the way through 55, 11. So, okay, you was with them at the condo afterwards. I was there. I mean, that.
All of that, we would object to it being redacted out. All of this is Mr. Copeland talking about.
Okay, so, all right.
Not Mr. Copeland, Mr. Zachary, not So I don't know how.
Okay, so now I'm seeing Mr. Shard as I read on further. He's going back to the, well, that's what they say. I don't know for a fact.
Right.
I see what you, no, I mean, I hadn't read that part before. Who did they say? God, I don't even know if we're talking about the street here, because you was with them at the condo afterwards. I was there, but shoot. That what they say? I don't know for a fact.
Right.
I'm saying, who did they say killed him? He may at this point mean, who did they, the people you are at the condo with, say? So can anybody actually point me to who the they is? If I flip back far enough?
In this particular interview, no, not as it relates to.
Oh, good
this
Lord.
statement right here. Because it's one of those.
It's all over the place.
No, it's as it relates to the way that Dennis is talking to Zachary.
Yeah.
He means it just like if I were to just pop up and say, who did they say did it? There's no they identified.
Is there a video of this?
Yeah.
All right, I may need to watch the video of this part, because maybe the inflection will let me know whether he means, let me watch the video on this. Can y'all send me that and then give me a timestamp for this part? Let me revisit that whole thing, including the 18 through 22 part.
If you send, I don't know if you have the times marked, but if you send the video that shows Mr. Zachary's face kind of zoomed in, I think it's an MP4 video. I think it's right around 27 minutes, 30 seconds.
27 minutes, 30 seconds?
I
Okay.
believe so.
Thank you.
Per my notes.
Okay, thanks.
Are we gonna move, to the next one or just?
Yeah, no, I'll take a look at that offline unless y'all got it queued up right now. I'll take a look at that offline if y'all will send me that video. So yeah, let's, if 5722 through 23 is a separate kind of issue, we can move on to that one. All right.
I have 3 digits. I know it's meant to be a typo, probably. Is it just 5722 to 5723?
I think so. Your objection, Mr. Shart, here is 57 lines 22 and 23.
I'm going to withdraw that.
Okay. So that one is not objected to. All right. Moving on to number 14, which is page 60, line 19 through 61, line 20.
So, Your Honor, this is
I'm going to withdraw that one as well.
All right. Okay, then our next item is on page 65, lines 8 through 20.
We're on number 15.
Yes.
It's, and my objection to this is just incorrect rendition of the law, explaining, Investigator Dennis is explaining to Quindarius Zachary why he's guilty by association.
Yeah, yeah, and I suspect he was not offering that as here's what the law is. He was offering that as here's what we law enforcement consider you to be, but I can understand that. You wanna agree to that, Ms. Love?
Judge, is the court will give me, my counsel is sitting here whispering in my ear. The court will give me 1 second.
To get there and consider it, yes, I will give you a second to do that.
I'm here in the court.
We'll see. I'm give you about 10 more seconds to make your decision. Then I'm just gonna make my ruling.
I don't object to 65-8 through 65-20 coming out.
All right. So that is out by agreement.
And Your Honor,
Yes.
yeah, I don't have any objection. and then 16 starts at page 66. Line 12 through 66, line 18 is what I understand. Your Honor, this is one of the acts that's listed as an overt act in this indictment. As I'm reading it, page 66, line 12 starts out talking about the gun that Mr. Zachary got caught with on May the 7th, and then Investigator Dennis goes on to say the assault rifle you're in the video with, and he's saying what it came back to. And then you have Mr. Zachary saying that's Moon's gun. But he is acknowledging that he and Mr. Sledge, who the state alleges, Mr. Sledge already pled, but Mr. Zachary is indeed YSL. So they're swapping guns. We would just argue that this is evidence of count one and the gang count in this case.
That's not my issue.
Count one.
Okay, so do you have an issue with lines 8, lines, where is it? 12 through 18?
I do have an issue with 12 to 18. I don't have an issue with him saying that he gave the gun to Moontook or that's Moontook's gun. That's fine. What I have an issue with is saying with Investigator Dennis, saying that the ballistics from that gun matched the May 7th shooting of Lucci's Bennett's mom's house. And there's a couple reasons. It's not Bennett putting in evidence.
Okay, well, hang on. Maybe we can address your objection and still have in the portion that Ms. Love wants it for
So
by
really 16
redacting a smaller part of it.
I should have said 16 to 17 if I was to be more precise.
Okay, so any issue with just with redacting out 16 and 17, Investigator Dennis's statement about it having come back to that?
Not for the purposes of plenary seconds. No objection.
Okay. So that's 66, 17 through 18 out by agreement. Okay, and next we move to 68, 24, and 25.
It's
I was
yeah.
We're asking.
I don't, Mr. Sharp, did that have some issue?
Right, 60. They're going back to Lucci mom's house, and then they're saying the gun you got caught with has something on it until you didn't know until you went to court yesterday. So I think that should come out 6819.
Okay, so then maybe we just aren't lined up with line numbers.
Yeah, that's my
So 68, 19 through 21, right?
I would say.
25,
Because then they go to Lucci mom again.
well, 24 maybe?
Right, okay.
Okay, right?
Yes.
So 19 through 24, out.
And then.
All right, hang on, let's make sure that we've got agreement on that.
So 19 through 24, so that's page 60.
It's page 68, lines 19 through 24. Do you agree? It's basically the same issue.
The issue that I have here is that I would object to that because Mr. Zachary admits that it has shootings on it. You know, it's one of the guns used in one of the shootings. So, even though as it relates to the previous portion that I
Uh-huh.
agreed to, and arguably even with the previous portion, the effect on Mr. Zachary, him not denying that or him not expressing surprise, but instead saying, oh, that's no tools done. In this particular case, when Dennis says what he says, Mr. Zachary doesn't say, what? Oh my gosh, no. Instead, he says, it has shootings on it. Yeah, it has some shootings on it.
He says that because they told him in court the day before. He didn't know.
But Judge, Mr. Sharp can't be the witness in this particular instance.
I'm going by what the transcript says.
I'm saying though that he can't speak to why Mr. Zachary said, yeah, it has some shootings on it.
I'm gonna exclude that. I mean, honestly, it looks to me like he's saying, yeah, I mean, now that I know, I'm not surprised, but I mean, if that's what you wanted in for, make that argument, but I didn't hear that argument, so that would be lines.
Glanville would have let all this stuff in easily.
So you're saying, hang on, Mr. Sharp, on 68, where are you proposing that redaction start?
19 to 24.
19 to 24, okay. I am gonna exclude that.
And these had already been admitted under Glanville's case, so they're gonna have to go back.
All right, now moving to 69, lines 2 through 6.
And it's starting on January 26th, halfway through 2.
Okay.
Through 5, really.
Was that page 69, line 2?
Yes.
Yeah, lines 2 through 6, starting with on January 26th. I mean, they're basically again saying, hey, you had this gun at some point and we know that it was involved in this shooting. We'd like to know who gave you the gun. And they don't have an issue with, we'd like to know who gave you the gun. Just we found out later this came back to the shooting.
That's fine.
Okay, so that is 2 through 6, starting on January 26th, are out by agreement. Okay. And then 17 we already did, so the next one is actually 18, page 69, line 25 through 7213. And
Okay, so Judge, when Detective Dennis asks who shot up Lucci's mama's house on page 69 at line 25, and Mr. Zachary gives them an answer. I would argue that all of this is information that I should be able to ask him about. And if he doesn't, if he testifies inconsistently, he should be able to come in. I'm not looking at his reason for asking it to come out, so I wouldn't.
yeah, what's your,
There's no indication.
how he knows?
To the extent that my client was there, as he claims, there's no indication that he was there, and there's no indication of what his source of knowledge is. I think he's just passing along rumors. And so if he says, I was there when Lucci's mom's house was shot up and it was Shannon Stillwell that did it, then I don't really have a leg to stand on. But I don't believe he's going to say that and he needs firsthand knowledge or another exception or another hearsay exception. And I don't see it in the state just kind of saying, oh, well, he knows, so therefore it's admissible. There's just so much rumor and back and forth in this case. And I think that the investigators, I'm not trying to criticize them, but they're just trying to like gather information, not in preparation of trying the case, but just trying to get like some broad generalized what the word on the street is.
So, Your Honor, as with any evidence or testimony that we elicit or tender, we have to establish a foundation before it's admitted. So we would not be seeking, and this we don't believe is just rank hearsay. So we just have a different position, and we would ask that the court just allows the opportunity to lay the foundation and present it.
All right, and I assume that your foundation is going to be co-conspirator exception, that they all know this because they're in the gang and they communicate and they need to be able to know that argument. I mean, I would think so. And frankly, even on 73, when they asked about what about Thug's stepdad's house, he actually says, I don't know for sure who did that one. So, I mean, he's clearly, if he doesn't know, he's like, beats me on that one.
Well, I think, I don't speak for Mr. Zachary, but I could see a world where he's a layman. And so he's saying, well, I haven't heard, I don't know for sure means I haven't heard anyone, no one's told me about that. And I just think, I don't think the co-conspirator, and I'm not saying that Your Honor said this, but I don't believe that the co-conspirator exception is satisfied by just saying, oh, well, it was a bunch of co-conspirators talking. I think that they need to establish who said what to whom and where in the circumstances of that statement, so we can see if it falls under 801 D2E. And so that's, I'm in the blind right now as far as how the state plans to get into that. But what I don't want to happen is the state, when Mr. Zachary's on the stand, to try to bring up, well, who do you know who shot Lucci's mother's house? And he says, I don't know, I wasn't there. And then they say, well, didn't you tell the investigators that Woody and Shannon and Pokey did it? And it's like, it was just based on nothing, but it's already out there.
And Judge, that would be a leap. That would be to say who did it and then didn't you tell them. I would at the very least establish a basis for his knowledge, either from things that he has said previously or from things that he says on the stand. So it wouldn't be as if it would be some kind of backdoor way to get in somebody's name that, you know, is sitting here in the courtroom. It would be the proper pulling out of evidence of the witness on the stand. It would be establishing a foundation for his knowledge.
Okay, but we're assuming if this comes in, that it's coming in because it's coming in as an inconsistent statement, you're impeaching him, right? I mean, obviously, if he gets up and you ask him about it and he testifies to all of it on the stand, then there still might be a foundational objection, but then we deal with that then. But if you're getting it in because you're having to impeach him, that's what we're trying to decide now. And so I don't want to wait and have the jury there and make the jury go away while we figure out the basis of his knowledge, you know? So I don't know if we'll swing back around to that one. Okay.
You guys, I'm going to fix my lunch.
Let's see.
They're going to be going to lunch soon. So excuse the noise in the background, please. But I do intermittent fasting, so I need to be on.
I mean, and frankly, it's probably going to be the same. You're going to need the same information for a foundation, regardless of its as to his testimony on the stand or as to this, you know. But yeah, it kind of let us know what that's going to be, so that I can make a determination of whether it comes in, you know, potentially. Well, that was 18. You agree about 19, so we're moving to 20. And y'all just let me know when lunch gets here and we'll break. Oh, it is here? Okay, we're gonna break then.
All right.
All right. Great. So it's 12:15 right now. So far, Ms. Rosser has not been able to reach Mr. Melnick. So, it's probably more likely that it'll be tomorrow than today. So why don't we, I don't know, maybe I'll know more after lunch, but let's break until 1:30. Is that enough time, deputies, for getting everybody fed? Okay. See y'all back at 1:30.
All right, you guys. We're at lunch till 1:30. My audio is going to sound really weird because I'm in the kitchen. I'm making my lunch. Because I got to be on time with my fasting and closing my window. So tell me what you guys think so far. Would you like for me to recap where we are? It's been an interesting last few days. With this case, they have learned that there is an extra ex parte meeting that happened on the 7th with just the judge and the attorneys. And he was saying that he sees the stuff that's going on in the courtroom. He believes that they are guilty too. Mr. Melnick was working in cahoots with the defense attorneys. He said that they were all unethical and all of these things. He even offered to meet with them on the weekends where there would not be a court reporter available to try to get this case, these guys prosecuted, which kind of let them know that it was not a fair trial and he was being very partial to the defense and why he was ruling on things the way that he was and handling them the way that they were, and also why he got so defensive when he learned that ex parte meeting had been leaked. Kayla Bumpus took the stand yesterday and gave her testimony on what she witnessed in that the June 10th ex parte meeting. She took the stand on yesterday. One of the detectives took the stand on yesterday and also shed light to that there were some parts of the meeting between the prosecuting attorney and the judge was there, and it was asked to be kept off the record. So the rule of them kind of knowing like what took place and having evidence of that, now they have, but per the detective, they have testimony that there are still pieces of what happened in that room in those ex parte meetings that no one knows about, nor would they ever find out about, because it was asked to be kept off the record by the prosecuting attorney. Isn't that something? The judge asked questions herself to gain some clarity and to get some information. She did not like what she was hearing. Now she is revisiting having them pulled off this case and fired off this case. They're even revisiting involving the bar in all of these proceedings and reporting them to the bar. She's still pending her motion on the 2 mistrial motions. And now Lil Woody is set to testify before the jury comes back to see what he plans to say, if he's going to plead the 5th. Make sure everything that was communicated to him was in fact true, because the prosecuting and the judge gave him wrong information per this judge. So this is going to be interesting. And I am very curious to see if she's going to dismiss this case with prejudice. Man, y'all, the state messed this up royally. Ooh, y'all. Anyway, so that's kind of where we are. The jury's supposed to come back on Monday. The trial continues to move forward. She's just trying to get through everything that they need to get through and make as much progress pending on her motions. She's off on Friday, so I'm sure that we'll get something back by Friday or at least over the weekend on what she decides to rule upon. There was some very good arguments on yesterday. So much is so that it persuaded her to relook at disqualifying them. And she's been handling Miss Love left and right. I mean, handling her. So I'm going to fix my lunch. I'm already kind of eating because I want to be done eating before 1 o'clock. I'll be around to monitor the chat. You know, I don't want to come out of the live because it's too much work to kind of get things set back up and get all my disclaimers and all of that in there. So I'm not going to start a new live, but I am going to kind of like update the chapters in the description so that you guys can kind of know where we are. So I'm going to do that now. I don't want to do it that way. Stop it, girl. Here we are. Where are we on live?
Juvederm Day is coming soon. For one day,
Make this a little bigger. Hey, you guys, I'm back a few minutes early. Just popping in, just to see. I am going to do a quick recap before we come back from lunch. So, on Friday, we learned that there was an extra ex parte meeting, and there were a lot of arguments around that. So we know about the June 10th ex parte meeting, where Judge Glanville, both attorneys, District Attorneys Love and a District Attorney Hilton, along with Lil Woody and his representing attorney for the him pleading the fifth and being held in contempt regarding that, was Kayla Bumpus, a few detectives, a few bailiffs, like all of that was going on. And it was all of this discussion around that, all the laws being broken about it. And Judge Glanville eventually fired from the case. And now we have Judge Whitaker on the bench, who has been doing I think, in my opinion, our senses are high because of the corrupt that we witnessed, right? So our senses are high, but I think that she's been doing a pretty good job of trying to, be fair. So they learned that on June 7th, there was another ex parte meeting, and that was never disclosed to the court. And it kind of came out through happenstance because Attorney Brian Steele was like, there is something that's missing, because Judge Glanville comes into this June 10th meeting as if he's aware of more than he's supposed to be aware of, and there is something missing. So he basically flushed out that there was a meeting before that on June 7th that no one knew about. And in that meeting, it was just the judge and the two district attorneys saying that they know that these people are guilty. They see how the attorney for Kenneth Copeland looks like he's conspiring with the prosecutors, and like they threw out all of these different allegations and all of this kind of like gossip talk, like gossiping about this trial. And he's the judge who's supposed to be impartial. He even offered to have
calls and meetings with them over the weekend, knowing that there were no no court reporters available to even transcribe the meeting. So just completely off the rails, completely biased, clearly. And it gave so much insight into all of his rulings and why he was being so disrespectful, why he was overruling everything that the defense objected to, letting in all types of evidence that was not supposed to be let in. And that's according to the judge that's on the case now. So the attorneys were heated the next morning. The judge made sure that they got the transcripts. Like, she contacted Judge Glanville's court reporter and was like, let me get those transcripts. And as soon as she got them, she emailed them to him. So they read them and they were heated. Like, the injustice of it all, the attacks on their character, and from a judge, like, you have to rule this a mistrial. All of this has happened, is broken. I don't know how we're going to fix it. And so she told them to put their motions in writing and, blah, 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 blah. There were already motions, so they did some amended motions. One of them was that those two attorneys be fired from the case. She ruled on those and said that she would not fire the prosecuting attorneys. But on yesterday, they held court on yesterday, bringing in different witnesses from that ex parte meeting. One of them was Kayla Bumpus. Kayla Bumpus shed some really good insight into that they knew that Copeland was represented, although that they kept, trying to get him without his attorney representation. There was a meeting that happened off the record between the prosecuting attorney, her, and Woody, which is against the law. And the judge asked specific questions. Was this at the prosecuting attorney's discretion? Was she the one that advised that? Kayla was like, yes. They had an officer of the court to come in and testify, one of the detectives, and he had to be honest. And, the prosecuting attorney called him as a witness, and they probably should have left him off because he was honest. He said that they basically had ill-advised Lil Woody. He told him that what he would do, which would be have investigated him. He said that the off the record meeting happened. Judge Glanville was in that room. The attorneys was in that room, and they don't have record of what was actually discussed. So they have an argument there. Like, these are according to the Georgia Code of Conduct. Like, that's what they're giving this on. And the judge asked specific questions. She was very, very, very involved and very attentive. She was also very empathetic to Kayla Bumpus because Kayla was clearly nervous. She kind of muffed it up a little bit, but she got it back on track and gave them what they needed. So the attorneys were arguing, it's like for this to go unchecked and for you to not address it, or even to give, like, for you to sit on your hands, basically, you are giving them fuel to do what they're doing. You're basically condoning their bad behavior. And I thought that was very interesting as well. And the judge was clearly disgusted with defense attorney Love. Like, she was scowling at her. And she said, listen, when I made that ruling to not fire them, I was basing that ruling on kind of like, you can just take it up with the bar, meaning the bantering that was going back and forth. Given what I know today and what is kind of getting fleshed out, I may revisit that. And let's be mindful that we still have the two motions of the mistrial that I haven't ruled upon yet. I'm doing my best to get to it. You guys have given me a lot of motions, and it's a lot to catch up on. But rest assured, I take Brady because it was a Brady violation. The Brady violation was that, one, the ex parte meeting that they didn't disclose that happened on the 7th. And two, it was very clear that was additional conversation that happened in that room where the court reporter was advised to keep it off the record. And that's a Brady violation because the defense don't know what was said, and the defense has to have information to combat so that they can defend themselves against whatever that the witnesses may or may not say. So that was very interesting. And she said she takes it very seriously. And anyone should take it, Brady violations very seriously. And she is going to take it very seriously. And that means everyone, including the prosecuting attorney. So it's going to be interesting how the rest of this week plays out. I'm interested in it all. So I'm just kind of bringing it to you guys. I've also been kind of like on vacation for a week, really. So, you know, we got to get content out there and kind of keep this channel growing. Bama Girl 2.0 is getting ready to be launched, and that's going to be fun. It will be more in this lane, but we're going to be growing, and I have some competitions coming up for some money and some products and some things. Like, we're about to get lit on this channel. Look, I'm being all excited and so corny. Y'all know how I do. But I'm going to get to all my reviews. So rest assured, I'm coming. I'm going to be working on some things tonight. And tomorrow I'm going to punch it out, and then we're going to keep things moving. But I just thought this all was interesting, you guys. Especially the piece about these extra ex parte meetings. And now Lil Woody's testimony will either be, well, it has to be thrown out, right? But will they allow him to testify again? He does have the option to still plead the fifth, but the judge is really, really being fair and wanting to make sure that he has representation. They brought him in today. The first thing she wanted to know was, does he have an attorney, and can we get that attorney here? Attorney Melnick will hopefully represent him. She said she would even try to get someone to do it just on a favor for her. And the other thing, Melnick came in yesterday and he testified yesterday. So it was a big, big day in court yesterday. And I'm going to put together some things of like what I know so far or what I've listened to so far. Like, I'm going to put something together and kind of put that out there, but I think I'll put it over on the other channel. So today Brian Steele was like, listen, I want to ask him, did he feel pressured? I want to ask him about this ex parte meeting. I think we need to do that before the jury comes back. And she agreed. And Ms. Love was kind of like hesitant and arguing against it, but she was like, yeah, he does need to come in. So that's what they're waiting on now. He did come in, but they want to try to get him attorney representation. She's really trying to protect his rights. She told him while he was there that he was ill-advised, that he didn't get all the proper information. Like, basically they hoodwinked him to get his testimony, and she wants to make that right. And I thought that was, I like that. And that was commendable of her, even though it's her job. As we see, judges have a lot of wiggle room on how well or you know, they do their job or not. So I appreciated that from her, whether it's the Dog and Pony Show or not. I just appreciated her, you know, being that type of officer for the court. Another thing is when they were arguing about Lil Woody's interrogation video, the 9-hour video. And she was like, just because you think it's this doesn't mean that entire video come in. Well, they had already let the jury see that entire video. So they went over that and striked out a lot of things that was never supposed to be shown to the jury. So my questions are, you know, if they were to go forward with this case, how are they going to untaint the jury on everything that they've already heard and all the evidence that have been presented to them that they should not have ever heard? And so these defendants' rights were really violated as far as a fair trial. And this guy, that attorney with the bald head, the one who's been arguing mostly today, he made a very valid point. He said they are entitled to a fair trial from the beginning. That is their right. And so because we're trying to make it fair on the offside when it has already been unfair for 2 years, like, how do we remedy that? That is so broken. And she was like, listen, 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 I hear you. You know, I think she really wants to try this case to kind of show good faith. She's also standing 10 toes down on protecting Judge Glanville's bench, right? He is her boss. She does have to work with him. So she's trying her best to kind of protect the bench and the order and the representation of Georgia. And the attorney's like, listen, we got to show them this is not how we do things here. Like, they are disgusted. And I love to see that they are fighting so hard for these gentlemen. I won't even call them gentlemen because, you know, we don't know if they're guilty or not. I'm going to keep my opinion to myself because I live in these ATL streets and I'm not trying to be a target. Boop. At the same time, they're, you know, due process is due process and they have to prove it, right? So someone had asked a question in another chat and said, hey, well, can we at least say since they've been on trial, have all the crimes stopped? And the answer to that is absolutely not. They have not stopped. It's still crazy in ATL. It's not a real place, as they say. But yeah, I don't know if there's a difference or not a difference with all of this going on. At the same time, it has been very interesting. And I thought that was very interesting that that video should not have come into play. And, you know, the jury has already seen it. So where they are right now, they're going through the testimony, the transcripts from a testimony of the witness that's supposed to come on after Lil Woody, because Lil Woody is kind of still pending. They're going to have that conversation with him. They don't know whether he's going to even testify. So they're kind of putting that on the back burner until they can get all of that addressed and kind of moving on through the things. So what they're hashing through right now before they went to lunch was another transcript of a person who is to testify after Lil Woody. And it's things that's being strike from that and strike from that left and right. So there have been some wins for the state. There have been some wins for the defense. And the wins for the defense are huge because they had no wins under Glanville's, except for a little cookie crumbs that he threw them. So this is all interesting, you guys, and they should be back from lunch soon. I am just going to let this play because I kind of want a snack, and I'm not really sure if they're coming back at 1:30 or 2. So I will be here. I think I have everything up and running. I didn't want to stop the chat because, like I said, I'm stopped the live because it's so much work kind of get things set up. So I am going to let this stay that we're at lunch. I don't want to be eating you guys here. I need to drink water because I said I was going to close my fast. I got to keep doing what I'm supposed to be doing. But y'all, I had sugar while I was on this vacation. I have cut sugar mostly out of my diet. Bad things mostly out of my diet. And so when you have to kind of restart that and re-kick that, your body be like, give it to me now, Seymour. And that's kind of what's happening with me. Like them Debbie Snap cakes. Oh my goodness. I want me an oatmeal cream pie, a fudge round, and some M&Ms with peanuts and some hot cheese popcorn. All the things that I shouldn't be having. I closed my window at 1 something for a reason. I didn't fix me a smoothie. I'm so off track, you guys. I got to get back on there because, you know, I'm almost back to my military fighting weight. So, yeah. Can I leave it for tomorrow and just really buckle down the rest of this week? I got a lot to get done tonight. I kind of need the fix. What y'all think? I got time, don't I? I ain't gonna do it. I'm gonna leave it for the vine. Maybe I'll work out. I'll fix me a smoothie or something. Child all over the place, honey, but I sure want it. Anywho. We're here. Boredom is kicking in. That sugar is calling me for a few fleeting, and a Diet Coke. Y'all don't even understand. I'm getting sleepy. But these lives are worth it. I need the traction on my channel. Oh, I can make me some pancakes. Mm-mm-mm. Let me stop. I'm not. Let me leave it alone. That sure would be good, though. Hey, come on in. Welcome back. We should be coming back from lunch really soon here in about, I guess, maybe about 1:30 or so. So we're at lunch right now, but I appreciate you coming in. Thank you so, so much. Give your girl a like before you leave. Mm. Y'all, I think I am. I'm gonna go. So everything is set up, and I'll be right back. I want this snack. I can close at 2:00, and that'll still be a decent time. I need a little caffeine. So I'll be back.
Okay, maybe we're not coming back until 1:45, maybe? Excuse me. Here on here. Kind of wake stuff up. It's 2:10 and I'm gonna officially close my window.
may be adjudged in contempt and committed to the county jail until such time as such person purges himself. So
Okay, let me get maybe to the statute. Give me a second to get on Lexis. Unless you have a copy of it for me. That's fine. It'll just take me a second to get it pulled up. So you're talking about 24.5.507?
yes, Your Honor.
Okay. All right.
So just the plain language of the statute. So, just the plain language of the statute, Your Honor, which is essentially a statute, not saying that, the court can grant immunity, but that the state can grant it and we have to move the court. It lays out very specific steps that we have to take. And in.
Hang on a second. Can you not hear her? All right, can you, I don't know, do those mics move?
It wasn't on.
Okay,
It wasn't on.
there we go.
So as I was saying, the language of 24.5.507 lays out very specific steps. Only the state can grant immunity, but the court can compel the testimony, which we obviously can't do. And 24.5.507 is a statute that allows us the leeway, the grounds rather, the pathway to get a witness to testify after they have pled
Right.
The judge be like,
the fifth. And so section B of 24.5.507 says, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such a person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. I don't know why it only references the grand jury and not a petite jury, because the top portion of the statute in section A refers to both. And it talks about the fact that if you're needed in a criminal proceeding before a court or a grand jury, if your testimony is deemed by the district attorney necessary to the public interest, then the DA may ask the court to compel that person to testify. In any event, the last line, which says that if the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. I don't have the reason that they refer to the grand jury and don't reference the trial jury. But given the fact that the statute itself refers to them almost interchangeably in section A, when they say if you're either brought before the grand jury or a criminal proceeding. And so the fact that even after the grand jury is dissolved, the court can keep you there until you purge yourself of the contempt by giving the court testimony. The extrapolation that I made was you can be kept until you purge yourself of the contempt by testifying, because you don't have a right to assert a Fifth Amendment privilege.
Right. So one thing I would wonder about with regard to that argument is it's sort of a kind of basic canon of statutory construction that if certain language is used in a part of a statute and then it is not used in another part, that there's a reason that it's not used, that there's some significance to at one point saying before a court or grand jury, because they clearly knew they could use different language. So the fact that they didn't include it all in the second part, there might be a reason for it. So that I think kind of cuts against the argument that I can hold Mr. Copeland throughout all three trials. So I think we need, if there's some sort of case law that indicates that if the testimony at issue is before, like for a trial, that somebody can be held even after the trial is over until such time as they decide to come testify in front of a court about it. So
someone sent me a case, but I
okay.
haven't fully got it. It's in re Long, 276 Georgia App 306. I'm reading it.
Okay. And if anybody on the defense side of the room's got a case that says the opposite, then that would also help us out. You know, that answers the question the other way. It just seems to me like if he's under subpoena for a trial, then the point in which it would logically end would be when the trial is over. And I get he may never still purge himself of the contempt, but
and in re and it's a 2005 case, Judge, so I haven't looked carefully at it, so I don't know if it's cited in the annotations.
it is for a different proposition. I haven't read it myself either, but I don't know that this case really answers the question we're asking. Anybody have any other kind of case? I mean, my position without a case to say it clearly one way or another is I sort of feel like it couldn't go past the end of the trial. But I know that. I mean, one way or another, I'm willing to be persuaded differently if we've got law.
Your Honor, I don't have a case on the point, however, it would make logical sense that it couldn't go past the end of the trial, however Mr. Copeland purged himself of contempt at the interim time between two trials.
Yeah, I mean, I guess the same way that they suggest that if the grand jury is over with, you can come purge yourself by testifying in front of the court. Not that either of those really achieves the end that is sought by the immunity order, but it's a way to purge. But, you know.
And arguably, the testimony would be under oath and available.
It was not going to be available at, I mean.
Not at that trial.
Right.
Yeah.
So I'm sort of going with through the end of this trial unless somebody tells me differently. All right, has anybody come up with anything else that he ought to be advised about?
Your Honor, I know that the court did advise him that Westmoreland, can you hear me? I know that the court advised him that he was told some things that were not entirely accurate. And just listening to the testimony and looking at the transcript of what he was told, as the court sits now, are there particular points that the court has concerns about? Because regarding perjury, the statute sort of lays it out. And I know that before he testified, the last time, Judge Glanville, I think, gave him a
Gave
copy of
Ms. Bumpus to give to him, I think.
No, actually, while Mr. Copeland was on the stand, I think.
Oh, in court.
Yes,
Okay.
he gave to Mr. Copeland, read to him or gave it to him a copy of the statute and apprised him. I think he made.
Okay, right. But all of that was before the ex parte. Y'all, it's already too hot, so I'm gonna have to turn it back up.
Okay.
But I went up a whole degree, so I'm seeing if a half degree will make a difference.
I will survive. So
what were we saying? Oh, yeah. So that was in court, but then the ex parte occurred after that.
It did.
And much early, much closer in time to when he ended up testifying. So I'm thinking that probably was well, who knows, but that may have been the thing on his mind at the time. So one thing, and I mean, there's, this is he comes in on page, at 10:03, and it goes until 11:30. And I mean, there may have been a break or two in there, but so I realized that it's not just he's told one thing at one point in time, and that's really unclear. I mean, it may be that the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate. Just as an example, if I can find it. Okay, so on page 51, the example, and I know what Ms. Hilton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hilton were trying to make sure he understood. But Ms. Hilton says, your example that you gave me, what if I said I did something and I know you didn't do it, and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury. It might not be, but, I mean, there'd have to be some, proof that it's a lie. But to say that's not perjury is technically not necessarily correct. And you're also talking to a layperson. And he clearly, I don't think, understands. I mean, he even says, I don't understand any of this at the outset. And, we're talking about purge versus perjury. And I just think we need to make sure we give him clear instructions, and then he can make a decision.
Yes, Your Honor. And I know that I think I said on the record regarding his attempt to sort of get that information before he took the stand.
What happened?
what he talking about, and then they asked me about.
From the start, and
All right. And
reading it.
from both sides, whatever they think would be appropriate to advise him about. And I can then take it all and look at it and
Sure.
put it together. I'm not saying just because y'all asked for it, I'm going to advise it, but I would like your input on it, particularly given issues that have been complained about his prior advisement. So,
Good.
all right. Okay, so let's turn to, somebody needs a bathroom break. So I know we just got back here 30 minutes ago. Y'all should have gone to the bathroom before then, but we'll take a bathroom break quickly. I'm just going to stay here. Now I'm going to be on page. We're now going to be on page 75, lines 10 through 78, line 1. Hearsay about who shot at Woody and who shot Boo, and I'll have to look at it. Oh, and by the way, I was, going to circle back and listen and look at the video on that one item, and nobody, to my knowledge, sent me the video, so I haven't been able to look at it yet. Can y'all?
I uploaded, I neglected to inform the court, I uploaded to that Dropbox link for recording. So.
I don't know if I still have that Dropbox link. I don't know. Can you just shoot me the link again?
Yes, sure.
Okay.
I try to keep the same link for the transcript, so I will resend that link. And then there's one long version of the video, and there's a smaller one where it breaks it into smaller chunks. I've used DLC to operate. I don't know if the court has that player on your system.
I think so. I think we have that one.
I will resend that, Your Honor, right now.
All right, great. Thank you. Okay, so let me.
I recommend that you send smaller chunks, the bigger chunks have a harder time.
Actually sending, yeah. All right. And is this hearsay?
So part of it, Judge, what did you,
So we're at 75 line 10 through whatever the next thing is, 70, where are we? 78 line 1.
So I don't have any objection to 75 line 10, where Dennis says, what'd you hear about them when they tried to shoot Woody? All the way down to line 17, no objection to that part. But when Quindarius Zachary starts talking about, when he says, oh, you talking about where they got shot at, and then Dennis clarifies when they made this post the following day, Zachary says that's when their spot got shot up. That was the next day though, you're right. And when I think it could be seen a number of ways, but when he says Woody went to the hotel party and basically Kel got locked up when Moochie's mama's house got shot up, and Zachary says, yeah. And Dennis says, right. And Zachary says, yeah. If that portion is being offered for hearsay, if that portion is being objected to on the grounds of hearsay, I would say that that's just a matter of showing the proper foundation. And I would ask that that not be excluded before that foundation is properly laid. If it can't be laid, if we don't lay it, then we don't try to get it in. and we don't backdoor it in any way. So I would object to lines 18 through 23 on page 75, lines 1 through 6 on page 76. And as
Okay, well, I mean, that all seems to kind of be like the question on the floor for discussion, right? I mean, they're like saying, okay, what is it we're talking about now?
So, Judge.
Yeah.
Big Boo is someone who's deceased, but, oh, sorry. Big Boo is someone who is deceased, but what they're talking about, him getting shot at, that was not what killed him, to my understanding. But this is all just nothing that Mr. Zachary, to my understanding, has any firsthand knowledge of. And then they talk about Woody getting shot at when he went to a hotel party. That case was never charged. I've never seen anyone say they know who shot at him, and this is just more speculation and hearsay. I have no reason to believe that Mr. Zachary was at that party. And then
I withdraw the objection. I'll stipulate.
Okay, so that carries us through all of 76 or down through more, it looks like.
Well, then they
Through
start
78, line 1.
Okay, all of it.
Yeah.
Okay. Thank you. So that entirety of what is represented by our number 20 is redacted by agreement. All right, 21, that's page 79, line 14 through 22. Speculation about who shot at Thug's stepdad's house. Hang on, 14. Yeah, I mean, it's pretty clearly speculation.
We don't have a problem with
Okay,
that.
so that is out by agreement. So we pick up from there on line 23 down through 81, line 5.
and that's just, Your Honor, Tyreek, I think there's a gentleman named TJ Rivers.
Uh-huh.
I believe that's his last name. He's not charged in this case. And then Tyreek was his brother, and apparently he was killed by someone at some point.
Yeah, I mean,
has-
that all seems just like, they're kind of like, well, while we've got you in here, what might you know about any other shooting that ever occurred?
Right.
Yeah.
It has nothing to do with this case, as far as I know.
What say you, Ms. Love?
I have no objection to, I'm just gonna go down the list, the latter, page 79, 23 through 24. I have no objection to page 80, the entirety of page 80.
Child, they've been going through this transcript so long. I don't know if this is testimony, interrogation, or the transcript from the court.
Up through page 80.
I think it's the transcript from there.
They're saying 81, line 5. Let's deal with that. I mean, that all looks like.
So Slug, Trontalia Stevens is a member of YSL. He's already entered a plea in this case. And Quindarius Zachary's association, knowledge of, affiliation with Trontavia Stevens. When Investigator Dennis says it went quiet for a little while, and then Mr. Zachary, that is, gives this explanation.
Is that supposed to say?
I can go without that. So
All right,
1 through
so-
5 I'll
Okay,
stipulate.
all right. Thank you. All right, and then our next thing is so that one's incomplete, it looks like. 81, line 13 through 82, line what, Mr. Sharp?
I think to the end of 82. Oh, well. You know, I would say 82 line 6. Or actually 82 line 3. I don't really have a strong opinion about it. My problem is when the police start talking about ballistics and this matching this. I mean, if it's relevant, that information obviously can come in if it's relevant and you know, fulfills all the other requirements, but that would come in through a GBI expert matching ballistics, not through Investigator Dennis sharing information with Mr. Zachary.
Yeah, okay, so Ms. Love?
I have, if it is, and Judge, I apologize, Mr. Atkins just apprised me our server's down, so he wanted to get my external drive to share those videos with you.
All right.
So I was.
That's okay. So we're talking about 81 line 13 through 82 line 3 and
Okay, back on
No
track.
objection to the rest of 81. So from line 13 down, no objection to that. So 13 to 23.
no, yeah, through 82 line 3.
No objection.
Okay. Thank you. All right. Now we are looking at 83 line 18 through 84 line 21.
That's already been agreed to.
Oh, perfect. Okay. We're looking at 88 lines 1 through 13.
So, Your Honor, let me be clear. This is my understanding. Mr. Zachary, after I read this, and then I've since read his other statement. I reviewed them both. I should
Right.
say. I've read them before, but I was unclear if Mr. Zachary was claiming to have been present at the club compound incident. After reading the first in time, second in that I reviewed statement, it's clear to me that he does claim to have been at compound.
Okay.
My understanding, but there seems to be a blending of what he saw versus what he was told, because my understanding is at some point he flees from the area. He is definitely, by his own words, not on 285 when Lil Wayne's bus is shot. So he can testify, or he has firsthand knowledge, presumably, about things he saw while he was there. But when he says Pee Wee ain't do the shooting, he wasn't there for the shooting. And when he says, I know who left and went behind it though, and he says DK and Shannon. So he's saying Walter Murphy, who's entered a plea deal, my client, went behind Pee Wee's car, Jimmy Winfrey's car. So to the extent that he has firsthand knowledge of things, I concede that he can testify to what he saw, and anything he has firsthand knowledge of that is inconsistent, if he had in fact had firsthand knowledge, he can be impeached. But there's certain things that he speculates, or maybe someone told him, I don't know, but it's not clear to me. So Pee Wee didn't do the shooting. That's a conclusion. He did not witness the shooting. He did not witness anyone do the shooting. So I think that's inappropriate.
Okay, so that is 88 lines 1 through 3, basically. And even the police are like, yeah, we know he didn't do the shooting. So,
Well, people in Cobb County would be interested in that, but.
okay, well, I don't know. I mean, maybe they're just saying that to see what he's going to say.
But then he says, I don't know who was exactly in the car. I know who left out and went behind it though.
Yeah.
So to the extent that if he witnessed a cars leave compound, I get it.
Right.
But beyond that, things that he did not witness, that's what I'm objecting.
I understand. So I'm trying to kind of take it piece by piece, because you're saying he cannot say with certainty Pee Wee did not do it unless Pee Wee was with him at the time.
Amongst themselves.
Okay, do you have any basis for?
Well, the portion of it where, so Mr. Zachary, like Mr. Copeland, makes assertions about the shooting itself and who was doing what. And the way that the shooting happened is a person is driving down the road next to a bus. And in order to be able to both drive the car and shoot the bus, from the way that both vehicles are positioned, you would literally have to have one hand on the wheel, and it was a precarious kind of circumstance that would be needed for the driver of the car, who is Mr. Winfrey, to also be able to at the same time fire the gun and shoot the bus. So in as much as it reflects his personal knowledge of all the people who were there and what was going on, we would argue that his assertion that Pee Wee didn't do the shooting would be subject to a foundation that, you know, we would.
There she go with this foundation thing. Yeah.
I think that he is just saying he didn't do the shooting. He was a party to the crime, but he didn't do it. He was driving. He couldn't have. But
So is Mr. Zachary in a second car that's involved in this?
so he is in another car, but he's not shooting. He's not in that.
He's not in the shooter car, but he says, you know, me and these other people went the other way. So he's
compound.
right.
Everybody shows up at this one place where
Yep.
the plane is in about 5, 6 different cars.
Okay.
And 2 of them at least follow the tour bus.
Okay.
He is not in one of the ones that follow the tour bus.
Okay. But he's there when you have reason to, you have evidence that will support that he was there to be able to say at least that as to the car that wasn't, as to some car, the car that went behind it, that he saw who was in those cars?
Yes, he says, Mr. Zachary says, I know who left out and went behind the car. So he says, and the fact that he's asserting DK and Shannon, if if he's crossed on that, I would argue that goes, it's way not its admissibility of Mr. Sharp.
Okay, but yes, and thank you. But I guess what I'm at, or what I'm trying to get clarification on is Mr. Zachary. It sounds like from what he's saying is he's there when everybody kind of goes in whatever direction they're going. And you're saying that that's his basis of knowledge for who's in what car, right?
Yes.
Okay.
Even at the point where, like in line 14 of page 88, he's saying, me and Trontavious, we don't went the other
Right.
way. Yes.
It sounds like that's all kind of contemporaneous that they're leaving out. Okay, so then I get that there is a basis on which to believe that he has firsthand knowledge to be able to say, I know who left out and went behind it. Who was that? Well, here's who it was. But coming back to the Pee-wee ain't done the shooting, if that's something you want in, then how does he know that? What's your basis for him being able to say that?
At this time, I wouldn't even proffer it. So I would agree to it unless something is said that changes.
Okay.
Because I don't have, there's never been a time where I heard him say, you know.
Okay, so then by agreement then, well then why do we need 2 and 3 and 4? Because they're just confusing without line 1, right? So 1 through 4 are out by agreement. So then 5 through 13, well, 5 through, how about?
The judge took her. I'm sorry, that was nice. That was funny.
How about that? I mean, the 5 through 9, I see as kind of a one little answer that he seems to be able to know. They say truth was with them.
That little answer.
And then
She trolling.
What about that part?
I don't mind 12 through 13 coming out.
Okay. Okay.
So we're at, the next one is 90, page 90, 11, page 90, line 11 through 90, line 14.
Correct.
Those are words of the police.
Oh, Mr. Melnick is here now. So he's on, not here, on the Zoom, virtually here. Do y'all all have the Zoom link? I mean, you're welcome to.
Oh,
I assume it'll show up on, does it show up on that big
Melnick is on
screen?
that phone.
All right, so y'all can just watch it on the big screen.
Are you ready for me?
I am. I think I say yes, and yet I think I need to probably turn my camera on. There we go. Hi, Mr. Melnick.
Good afternoon, Judge.
We can't get enough of you. All right, so the reason I have asked again for you to join us, and thanks for doing this by Zoom at very short notice, but so I have essentially determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland, and he has an immunity. There is an immunity order in place. He has immunity protection. And I plan to bring him in and find out what he wants to do. And I would like for him to be counseled. And I just had him in here a couple of hours ago and asked him if he had an attorney. And he seems to think that you are his attorney still. And so I'm checking in with you to find out whether that is the fact, either still or again, whether you're going to be representing him, because I'm looking for somebody to just ensure that he is properly advised of what the immunity order means, what he could face contempt-wise, what perjury means, what inconsistent statement means, the typical things you would want to advise your client who's going to be a witness in a criminal case.
Sure. So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay. All right. So, and you're representing that you have in fact already advised him of all of those things.
Yes.
Okay. All right. So I would propose to, unless he just wants to come back this afternoon. I mean, I did think I told him to be available maybe 3-ish. But if you want to be with us by Zoom, but are you available tomorrow to be here in person if we can have him here in person? That way, if he does have questions as anything's going along, and we're not going to take testimony, I just want to find out tomorrow, does he have any questions? Make sure we clear up a few things and then, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified to and start over.
Your Honor.
He should be there right now.
Okay. Oh, he's here right now. Okay. Apparently he's outside. So do you want to just stand by with us? And if he has any questions?
Sure.
Okay.
And Your Honor, before he's brought in,
yeah,
I would object to him being asked at this. I'm gonna just talk loud. Your Honor, I would object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been so that he's made statements. Obviously, the state has brought him in as their witness to proper testimony against people in the courtroom. And he's made representations, true or false, he's made them regarding concerns that he has. He's made them in previous interviews with investigators, not just you.
Okay.
So, Your Honor, in the interest of not having sort of the opposite effect on him, and I'm not suggesting the court would, I'm just suggesting that perhaps asking him at this point might have a
when do you propose I ask him? Because if I don't know exactly what you are suggesting, and I could be entirely off, but if you're suggesting that are you suggesting he has safety concerns?
Well, he has made statements about people being willing to have him killed. Okay.
All right. Well, to the extent that those might be any of the people currently on trial, he is at some point going to have to sit in this witness box and say, with all of the defendants present, yes, I am going to testify because y'all are forcing me to because of the immunity order, or I do not care, throw me in jail, essentially. So that's going to have to be in open court in front of everybody. So if that's your objection, so would you rather I do it Friday? I mean, I don't understand what it is you want me to do.
It was a preference, but I'm going to, of course, defer to the court. It's just, as I work through everything that I know has taken place, I'm just trying to make certain that.
Baby, goose finna be cooked.
Okay, I'm not trying to create a. No, I understand, and I mean I'm just not sure what else. I can do it at a later time, but I don't know what that gets us really, other than more uncertainty. And I also realize he may say one thing right now and then another thing right before he is brought out in front of a jury. I don't know. We can still check with him again because we're not having a we are not at this point having a jury in here tomorrow. So at the point when we get to a jury, if we get to a jury again, then I can ask him again to make sure. I think that would probably be advisable, but everybody's here right now. So I would propose that we do this kind of right now. But before I bring him in, does anybody have anything they want to make sure I make clear with him?
Not for me, Judge.
Okay, so Mr. Melnick, you weren't here when we had our discussions about what was the outer limit of how long the court could hold him if he chooses not to testify. And it is my belief that the longest he could be held would on contempt would be through the end of this trial. So if you need further discussions with him, let me know that.
I don't think so, Judge.
Okay. All right.
And Your Honor, and I know Mr. Melnick obviously knows how to do his job, but he wasn't, and I don't know how much he's reviewed the transcript.
Let me actually ask him, have you reviewed that transcript of the June 10th ex parte?
Mostly. I haven't. I can't say I've sat and studied every single word of it, but I've mostly reviewed
Okay.
it. Yeah.
So, I mean, the defense believes, and I don't necessarily disagree, that there, in addition to a different interpretation of how long he could be held, there is currently a different interpretation of the correctness of the advice about statutes of limitation. And we also think it doesn't ultimately matter because what is protecting him should he testify to something that he did that's criminal is not whether a statute has run or not anyway, it's that he has immunity. But it's possible that a couple of, every statute that you could be worried about has run is not accurate. So, I think you were aware of where in there they said something about a statute, and you're probably aware that there are things he could still be charged with. And does he understand that not every statute has necessarily run on everything he might be criminally involved in, but it doesn't matter because of this immunity order? Or I don't know whether, go ahead.
Yes, Your Honor.
Okay.
He understands.
All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
Certainly he does.
Okay. Anything else y'all can think of on either side of the aisle?
Dun, 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 dun.
Okay.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Okay. And I my interpretation of the immunity order is use and derivative use. But of course, we're not the feds.
And Your Honor, the court has every ability to do this, but I would object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So, I invited them to say that. So I don't know whether you want any additional time, having heard that potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. All right.
Judges, like I asked
Okay.
them, they ain't just
Is there a screen where he can
doing
actually see
whatever.
Mr. Melnick over there somewhere? Okay, thank you. All right. Let's go ahead and get Mr. Copeland in.
Uh-oh.
You see it, Wonder.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench in the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right, so.
No, I'm saying, like, I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah, that's one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is, it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is.
So I ain't got to wait till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions? Okay. And do you want to talk to Mr. Melnick any more about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them, we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you say, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
You can,
I
yeah,
have
if you
told
have
the
a,
state
Huh?
I have told the state I have lied and lied
I
and
know,
lied and
I
lied.
know. And,
So how are they gonna be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
They said they're gonna be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
not prior. You've said you've lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and well, maybe not, never mind, don't do
Can I
that.
give you an example for what they told me?
Yeah, yes, and then I'll see whether that's what I think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right, what was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth, okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can say, I can admit to a crime on the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime, here's what I committed it with, I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they don't have
formally call it.
they facts together? Like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me. I'll tell you whatever I'm going to tell you. Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go for now.
Oh, Woody.
All right, Mr. Melnick, please be with us at 8:45 on Monday morning. Can you do that?
Okay.
Thank
I'm
you.
on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right. Thank you. Appreciate it.
Woody playing is smart, y'all. Is he gonna get everybody off? Because that's gonna make her have to
All
make
right.
a
So
decision.
there we have our answer to the extent we have an answer.
Because she still
We will
got
revisit this
emotions out
on
there.
Monday morning. which is, by the way, when I plan to have the jury back. And we at least, I have some degree of confidence that he understands what his choices are and what his consequences are.
Oh yeah, we're gonna have
Back
to
to
stay and talk
Mr.
about this
Zachary's
after.
testimony.
Mm-mm-mm.
Everybody good? I mean, I know we just took a break. Anybody need a break before we dive back in again? Yes, all right. I didn't take a break before, so I could use one now. Let's take 10 minutes. Be back at 5 after 3.
Yes. Yes, he is. He is. He is playing their game. He is playing their game. Hey, bruh, BJ with the. Okay, thank you so much for joining. I don't know if you're still here, but thank you. Thank you. Thank you. I'm going to go and subscribe to your channel. Hope you'll return the subscription. But yes, 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 yes. Woody may free everybody. Oh, you a chick? Got my bad, girl, my bad. I'm going to subscribe to your channel. I am so excited that you're here. I am so excited that you're here. Please stick around. I'd love for you to come up if you want to. I'm open. I'm an open panel, girl. But it looks like Woody may free everybody because she still has to wait. Look, I'm so excited. I'm talking so loud. She still has to weigh in on those motions. She said yesterday, oh, you did? Thank you, thank you, thank you. I'm gonna go subscribe to you right now. While I'm talking to you about this. So she still has to decide on the 2 motions, right? She has 2 motions to dismiss with prejudice, and then she has the motion to fire the district attorneys that prosecuted that case. And she said, I don't know if you watched court on yesterday, but she said on yesterday that she is going to revisit that. So she has an appointment Friday, but she's got those motions. This whole thing may get thrown out, and Woody may free everybody if he waited out till Monday. I love that he said he gonna wait it out till Monday. I love it. What you think about it? Have you been following it? Let me get to your that's not you. Okay, I got to search for you. Let me put you in the search thing. I'm coming back to the chat. So let's see. All right, I'm gonna put you up on the screen, girl, because I like to shout people out. If anybody watches this, go with my girl BJ with the shits TV. I'm gonna check you out. I know you got some good stuff on there. He the key to freeing everybody. Look at his body language. Also, he getting a clear understanding of how to play. That is so true, girl. That is so true. That is so true. Because like bruh said, like he didn't want to testify anyway. And Mr. Brian Steele is who asked for him to come in, asked if they could question him, because Brian Steele wants to ask him, did he feel pressure? So if he gets up there and testify, Brian Steele gonna get his testimony thrown out again anyway. But I mean, pleading the fifth and saying that she may dismiss this whole case and he can sit in jail, child Woody. Shout out to Lil Woody. Hey, welcome. We got another person in here, girl. We got another person. Okay, I have to find you. Let me find you so I don't forget, because I haven't quite learned how to save my chats. Let's see. Let's see if I can find you. Oh, you know what I can do? Because you I think I probably can find you if I go and watch, like I'm watching my own thing. But let me. Oh, I found you. Okay, let me subscribe. Oh. Okay. All right, I found you, boo. I am subscribed. I love the love, and I love the cohesion. I love it. Okay. Girl, tell me about it. Listen, tell me about it. When Brian Steele and the bald-headed guy who was filming, I don't know if you know about that second ex parte meeting that they found out about.
But the way he been going to bat for his clients, man, and for these people that look like us and how they fighting for these boys, it just it tells me what people are up against when they can't afford representation. And three, they don't even have to go this hard, but they've been going hard in the paint. They've been given, since they have a voice now and the judge is actually listening to them, baby, they've been giving that lady the devil, and I love every minute of it. Even the judge has been getting in on her. Let's see what your next comment. I'm still trying to figure out how I want to do my lives. I got so much content to talk about. Oh, okay. I mean, I can help you. I'm still working on it too. And I have another channel that I'm launching. It's called Bama Girl 2.0. So I'll send you a thing. Well, I'll be on there more live, following this kind of stuff, more court kind of, like that kind of stuff. It doesn't really fit on this platform. But are you using StreamYard? And are you going to go live, or are you going to try to do an avatar kind of thing? Have you thought about that? Or you can ask me specific questions on what I did. I don't know, girl. I'm still new. I just started this channel. I just really started this channel kind of like June. Okay, look, check this out. Cause I love, we all have questions. If you want to link, my email is in my bio. If you want to link there, and so is my social media that's connected to this account. So if you want to just kind of chat or collaborate, or give me a list of your questions, I don't know. I like StreamYard. Most of the people that I watch that have, like done streams, that's where I learned is StreamYard. YouTube Live doesn't give the same juice, and it works a little differently. But with StreamYard, you can do pre-recorded streams. You say you're undecided. I wanted to share my point of views on these content creators' lies, play in games. Oh, let's see. Lies, plays, and games. Oh, I see. I understand what you mean. You mean kind of like what your subjects are gonna, like what you will talk about. Have you tried collaborating with some of the people that you watch, or catching their lives and asking to join in kind of thing? Some people are open. So is StreamYard better? I think StreamYard is better. I took a class. I took a like a tutorial on everything, and StreamYard was the one that she gave me. I didn't get a different type, but I've noticed that a lot of the people that are on here, they use StreamYard. And StreamYard, if you don't mind so you can get practice with it and see what you like, it's free if you don't mind their logo being in your stream. So you can try it out and get a feel for it. And then it's not a whole lot to subscribe to get, like, to be able to invite people on stage and share your screen and that kind of thing. But and you get less hours that you can record, but at least it's free to kind of get you, accustomed to it, or, to see if it's something that you like. I can tell you what I like about StreamYard is that you can schedule your lives and set everything up and then go live. The thing about talking with creators, they kick you off if you disagree with them or state your opinion instead of, oh, well, maybe those are just not the best people to collaborate with. If you, I can tell you that I just got connected with, her name is something Paris. I don't know, the blogger that recently got into all that beef with Cardi B. Her name is Just Landed in Paris. She is a co-host on a podcast. If you can find her page, and I may pin it in a comment or something, but she goes live with a co-host. Oh, you've been a girl. I'm telling you, just crashed into this thing. 2000, I mean, not even 2000. 2024 June. But what I was gonna say is she hosts a well, she's a co-host on a podcast, and they're very open. Um, I caught their live, I believe it was last Monday, but if you go to her page, you'll be able to see who it is that she collabs with. And they're very open and she speaks her mind. She's not an agree to disagree person. I mean, I'm sorry. She's not a go along to get along person. So she respects different opinions, and so does that platform. And I can pin her comment, but they talk about all kinds of stuff. Like the one that I listened to was baby mama drama, DNA. Her name is Just Landed in Paris or something like that. Hold on. I can tell you she has commented or did something on mine. Let me go to my page. I'm going to tell you. I want to say it's Just Landed in Paris, but I recently just got in, just kind of connected with her. So I don't want to tell you the wrong thing, but give me 1 second and I'm going to pin it in the comment here. I'm going to tell you and pin it. Let's see. I'm going to check out your channel. I've been on vacation for a week. It's Just Landed in Paris. Let me see here. Oh, okay, Mr. Fantastic 824. That's the person that she collaborates with too. So I'm gonna send you. This is what I'm gonna do. I'm gonna put this link to this video in the chat. I hope I ain't lose you. Oh, girl, did I lose you? Oh, no. Did I lose my live? Don't tell me. Duchess. Dang it. Uh-oh, maybe I didn't. I'm sorry. I did. Girl, I was finna have a fit. I thought I lost a live. Okay, so look here. I'm putting this link in the chat. And so you can click on that link because the person that the video that I just happened to click on, that's the one that it looks like they alternate hosting. But I know that they do that live and I've seen them kind of let people come up. Okay. And so I'm gonna tell you, you would like oh, I see. Let me pin your comment up here. Okay, so that's what you're more into, real life stuff, not the celebrity gossip and drama. This is good because in this channel, I do like a little bit of everything because it's one that I started to just kind of get my niche. But Bama Girl 2.0, it won't be any of the TV stuff. It'll be this trial thing, true crime stuff, the political stuff, just real life stuff. Like we're gonna really get into some stuff over there. So I'm launching that. I need to catch up on putting content out over here, but I plan to be over there definitely by later this week and get some content pushing over there. And I'm also going to push this over here. Okay, good. Okay, looks like they're back. All right, girl. I don't have no volume. Why? What I done did? Let me get over here and see. Oh, okay.
Okay.
I'm so glad you stopped through though. Like you don't even understand how you just warmed me. I'm just
All right, so I think we are on
I don't mean to call you sweetheart.
page 90,
I don't
lines
take offense at all.
11 through 14.
No offense taken, but I appreciate that. I look forward to catching up with you and seeing your stuff. Thank you. I'm so excited. You just made my day. Okay, back to this.
That's law enforcement speaking, basically saying that how Shannon involved in everything. So when they hear his beef, it's almost like call Shannon. That's the detective.
Yay,
And then
yay,
the other detective
yay.
follows it up with Shannon,
Oh, welcome.
the shooter.
Yeah.
Now, I will say on page 90, line 14, I should add this. I've reviewed all these statements and I've written notes where I feel that the transcript is insufficient. in my notes I have on 90 line 14, Underwood, Investigator Underwood says Shannon the shooter. And then Dennis says because, and then Underwood says Shannon the shooter again.
Okay.
So that's my objection, is the police labeling my client the shooter.
Well, the answer is good for your client.
I understand that, but I just.
But yeah. All right. What does the state say?
Your Honor, it's a question, it's not an assertion. They're asking is Shannon the shooter, and the inflection given by any person repeating it wouldn't do as much justice as listening to it.
Well, I will happily listen to that as well. But even if line 17 is a question that is saying Shannon the shooter,
right,
then we probably could just go with line 17 and not like the 11 through 16.
So
What do you think?
So 11 through 13, we would object to being excluded because that's Detective Dennis asking of Mr. Zachary something about one of the defendants currently on trial based on Mr. Zachary's relationship with him and affiliation with him. I don't have any objection to 14 through 16 coming out.
Okay.
That's what they want, but we would ask that the court, I think Mr. Atkins has had an opportunity to send the link to the, no, he hasn't. He said it's taken 31 minutes.
Yikes.
So I may be able to, I don't know if.
I mean, if y'all have it and can just pull it up, I can listen to it right now.
You can do that. Then also I'll bring it to you.
Talk into your mic, please.
On line 21.
Yes.
Investigator Dennis, my notes say, where it says indiscernible, says about that action.
About that action?
Yes.
Okay.
Speaking of Shannon.
And let me ask y'all, are y'all actually providing a transcript to the jury when you play these statements?
I believe we may have done it once, not with everyone, but I did intend that we clean up the ones that we have and provide a copy to the defense and see if they disagree with any cleanups and allow the jury to use the transcripts because they tend to prove helpful, but that we hadn't gotten to the cleanup part yet. We haven't cleaned it up entirely, and sometimes if the defense has a transcript they'd like us to use and like us to use, we welcome that as well. But right now,
Okay. And I don't know if the defense would have any kind of a position on whether on that issue.
There's a lot of issues with these transcripts, a whole lot, and just in all honesty, Your Honor, I don't see how we could agree to a transcript without all of us just sitting in here and going through it with a fine tooth comb.
No, I agree. And it may come to that, but it may be, a lot of times I think when audio video is played, at least in my courtroom upstairs, there are a lot of times when it's hard to hear. It's kind of like muffly. Even if I take it in my office and listen on my computer and I can hear it crystal clear, for whatever reason, once it gets out here and gets played through, whatever, it's not as clear. Now, maybe down here in 1C, it's a better audio video system and everything's been clear. But I guess if it comes to it, we'll sort it out then. But
Judge, I can on behalf of Mr. Williams, I can tell you at this point that we're going to object.
Like I hear this voice who is talking. All right.
It's God. I can tell you now that on behalf of Mr. Williams, we're going to object to the jury being provided any transcripts.
All right.
Based on everything that's happened so far.
What would the basis of your objection be?
It's been our experience thus far that we just have significant disagreement with the state on the transcripts that they've provided thus far.
Okay.
And we think, quite frankly, it's better for the jury to make their own determination about what's being said.
Okay. All right. Well, and I mean, it just may be that as we go on, if and when one day this trial wraps and a jury is deliberating, they may want to hear a whole lot over again, and we'll just all have to sit here and listen to it too. So y'all know that, and if that's what happens, that's what happens.
And Your Honor, we would also posit that there is the instruction that the court could give the jury about the transcripts not being evidence, and that they are indeed supposed to listen and take what they hear versus what's written on the piece of paper as
Sure.
evidence.
Yeah, I mean, so I just was raising that to find out, had y'all already come to any kind of an agreement? What was the practice here with this trial? So it sounds like if you want to do that, first off, you need to endeavor to the extent possible to come to agreement on what a transcript says. And then second, if it's necessary, I will sort out whether I'm going to permit that or not. And I'll listen to the legal reasons for or against. But okay, so if you can tell me, I know that first thing you gave me 27 minutes, 30 seconds. So for this one, where would I be listening? Oh, we're going to play it here. Never mind.
We need the Zoom link.
Oh, it's the same one as it was a minute ago when Mr. Melnick was on.
Okay.
And for this, because the only sound appears to be coming out of those two little strange white speakers, can y'all turn one my way? And I think that may be the subject or the reason for the squelch, but I'm not gonna be able to hear it otherwise, unless somebody wants to come up with a little speaker that I can have up here with me.
I did something to my blinds.
Judge, could the court give me just a minute? I'm trying to get it open and then
Yeah.
trying to get to that point.
Okay. And as long as we're gonna do this, we might as well listen to both of the ones, and I don't care which order we do it in, but.
Did I lose audio? Are they talking offline? Oh, they're getting ready to get into somebody else stuff. Okay.
There's a whole lot of days in here.
I think that it would be helpful for the court.
To just have the whole listen from the beginning. That's fine. I'll do that. That'll be my homework.
Does the court have, or Ms. Percival, have a thumb drive? Because I can easily just copy it onto that thumb drive. That's probably the easiest thing to do.
Probably not here, but definitely in my actual chambers. We've got one. Maybe Miss Bugs could bring us one down before we finish for the day. Okay. All right. So I think that answers on our number 25, which was page 90. We were gonna, by agreement, strike 14, 15, and 16, because you can't hear what they're saying anyway. But leave in, not by agreement, leave in 17 and 18. All right, so. Okay. All right, that takes us to 92, line 11 through 94, line 22. Dennis, investigator Dennis. Okay. So. So it's not the entirety of 92. That's just to give me context. Is it is it 93 line 21 where the real objection starts? 92 line 15. Oh, if y'all don't mind turning those speakers back around now so we don't have squelch.
So,
Matthews, bring around the corner. Bring around the corner.
Thanks.
Yeah, it's trying this way.
Okay.
So investigator Dennis was present. He was working an extra job at Club Compound, and he's already testified. And he's provided live testimony about what he observed at Club Compound. Right here, and I think admittedly in the statement, he's just kind of going off his memory and he's confused. And he's testifying about, not testifying, but he's talking to Quindarius about what he saw.
Right.
And we've already heard from him sworn in court testimony about what he saw that night. And this is, in several of the interviews, he goes into what he saw that night. And I just think it's inappropriate for the jury to get investigator Dennis's version of events through unsworn out of court statements. And they're likely to confuse it with what he said on the stand.
Okay. So can you pinpoint for me on page 92, is there anything? Well, I guess line 15, like.
Right. He's leading into it. He's talking about DK, who's Walter Murphy, and I believe it was Pokey. That's Kaikendo, and he's actually wrong about that. Fatty is Kaikendo. And so he's just kind of setting the stage of the people he saw. And then
starting at where? 15?
15.
Okay. Yeah.
And then he's talking about the gun that DK had a gun and he recovered the gun and how he pulled out his gun and Jeffrey's sister Max took offense to it and how the gun was put on Dolly. Dolly is Max. That's the same person. It's on Dolly's truck.
Yeah.
And so he's just reliving what he observed that day. And I just don't think it's appropriate for it to be played in an out-of-court statement like this.
What's the state's response?
Your Honor, with respect to the sections about Detective Dennis relating and receiving input from Mr. Zachary, information about the Lil Wayne bus shooting, as Mr. Sharp said, Detective Dennis was there that night, and as he relayed what he saw, Mr. Zachary's reactions are the more important thing. Obviously, the jury has heard Detective Dennis on the stand, and particularly at line 93,
On which page?
I'm sorry.
Oh, page 93, line.
15 through 17, for instance.
Uh-huh.
Where Detective Dennis says, but DK had a gun. I recovered a gun from DK that night. And Zachary says, yeah, I saw that. So Detective Dennis's words impact on Zachary and his responses to them are the more important thing than us trying to have him, as Mr. Short said, testify. That's not what we're trying to do. Now, there are parts of these that we don't have a problem, consenting to.
All right, well, tell me what those parts are.
Well, let me.
Or the opposite. Tell me what parts you really maintain you want / need / believe you're entitled to get in.
So starting with taking out, I don't mind page 92, lines 11 through 25.
Okay. Well, so we'll redact that by agreement.
And I'm sorry, I missed what the court said.
I said we'll redact that by agreement.
Page 93. Lines 1 and 2.
Okay.
We would object to page 93. Lines 3 through 9.
Okay, so that you believe should be in.
Yes.
All right. And
that's because as Investigator Dennis is talking about Copeland, Fatty, and DK being like this, Mr. Zachary is making his assertions about who among them was actually there.
so he's actually showing I've got knowledge of this and okay. All right. Any response on the 3 through 9 of 93, Mr. Sharp?
No, I'm
All
fine
right.
with that.
So that is then in by agreement, essentially. All right.
As we go on further down.
And then
I have no objection to 19 through 23 coming out, where Investigator Dennis is talking about Poopy Dolls, not Poopy Dolls, but DK's gun having been taken.
right. Okay. All right, and so up above then, where he's saying DK had a gun, I recovered a gun. Yeah, I saw that. Is he literally mean, yeah, I saw that on the scene?
Yes.
Okay, yeah, that seems like that could come in. All right.
Okay, guys, I'm dropping this link because I want to stay and talk about some of this stuff after this is over. So I'm dropping this link here so that we can, if you want to come up on the screen, you can. You can put an avatar there if you don't want to be seen. But just so you guys know.
Mm-hmm.
And 25 on 93 lead into page 94, lines 1 and 2.
Okay.
We would object to that coming out.
Yeah, I mean, that seems like that's still the firsthand knowledge.
We have no objection to page 94, lines 3 through 6 coming out.
Okay. 3 through 6. 3 through 7.
Well,
Or
yeah, 3 through 7. That's fine.
okay.
Line 8 through 10. In, we would object to that coming out.
Okay.
We would object to line 11 through 18 coming out.
Mm-hmm.
We don't, actually, we would object to line 19 through 25 coming out as well. Specifically, were only that Detective Dennis said lines 19 through 22.
Right.
But then Mr. Zachary gives.
Is sort of agreeing and yeah, okay. All right. Any further argument on basically like lines 8 through 25, Mr. Shart?
No, Your Honor.
Okay, all right. I'm gonna permit that in.
Okay, she got to win.
And so
So is everybody clear on what's out and in, or do you want me to? Good. All right.
Even though she's letting us
so
stuff,
the next
they still have
section,
to
Your
lay
Honor,
foundation.
is kind of picks up right where we are. And I
So the
flagged
sheriff may
this
still never see
because it was unclear to me at the time whether Mr. Zachary was claiming that he was there, but I am satisfied that he is claiming that he was at the compound, but I think we need to review it with the knowledge of where he was at the compound and where he wasn't.
Okay.
What is based on firsthand knowledge versus what is speculation.
Can you speak to that, Ms. Love?
Which part are we talking about?
I mean, essentially like through the 94 line 24, I guess through 96 line 14.
So my first issue is on 94, he says, yeah, she swapped cars with them. With who? DK and Shannon. Okay, if he saw that, that's fine. You know, if he, of course, if the foundation is laid to ever play.
Right.
But then after he says DK and Shannon, investigator Dennis says are shooters. And Quindarius Zachary says, yeah. He wasn't present for the shooting.
Okay.
It's going back to, he has no firsthand knowledge to affirm investigator Dennis's theory. So I would have a problem with lines 1 and 2. And then I have a problem with investigator Dennis, who wasn't present, saying
Right.
Pee Wee in the white Camaro was just a driver. He doesn't know that. So I'm going to start out 95, 1 through 4.
Okay. So I think essentially that one is, okay, this is the law enforcement theory at this time, but.
So we're starting on
95 lines 1 through 4. Or, yeah.
At this time, Your Honor, well, I'll put it this way for open reserve, right? If I've asked that the are able to establish that foundation,
Mhm.
then I'd ask the court, not exclude.
Okay, and that foundation being the foundation that he actually does have.
Personal knowledge of it.
Okay.
Or some other.
Okay. Okay. Yeah, so that one is, I guess, a TBD.
And Your Honor, I want to also, say, so with respect to Mr. Zachary, he has, and the reason we have some TBDs by some of this is that he has not been the most cooperative person. And I just leave it.
Okay. All right, so we'll just see on that. I understand the objection. I understand that it can't actually quite be answered yet. There's a foundational issue. We'll just have to see. Okay. So then we've got, I guess, what? 6 through 14.
I don't have a problem with lines 6 through 8. But then again, he starts theorizing about who's a shooter and who's not. And he says Troop wasn't no shooter. He was there though. I think he was following them too.
I don't have an objection to, is that 9 through 13?
Yep.
Yeah.
I don't have any.
Okay.
And then I have a problem with 14 through 22. 14 through 25, really.
And is that same basis, like, how does he know this?
Correct.
Okay. Is that also by necessity TBD based on your frustration with your witness? Okay.
And
Well-
that leads into 96 as well.
Well, I would say 24 and 25, 95 lines 24 and 25 to 96 is really 96 line 14 is all speculation about why Jimmy Winfrey pled guilty. I don't think that's TBD. I think
Okay.
that would be
All right. So hang on. We've got, I'm sorry, maybe I'm just not up with y'all. So 95, 14 through 23 is TBD. Is that right?
That's right. Yes.
And then when we start on 24, line 24 and going on. Okay. That's yeah. I mean, so the objection is on page 96, what lines?
I don't have an objection to 96.
95 line 24 to 96 line 14.
I don't have an objection.
Okay, out by agreement. Okay, so are we now at number 29?
Yes.
Okay. Uh-huh.
So, Your Honor, the context of this is there's a gentleman named Rico Rich.
Mm-hmm.
Is it Rico Rich? Rico Rich. And he ran or owned a studio on Metropolitan that allegedly was also used at times by Mr. Williams.
Mm-hmm.
And at some point, this studio was raided, and marijuana was located at the studio, and I think Rico Rich was charged with it. It was his studio, my understanding. July 15, 2015 is when that raid occurred, and it has nothing to do with this case. And so they're just talking about Rico Rich being upset because his perception that the attention drawn by the gentleman in court led to the raid, and it's just about something that has nothing to do with this case.
All right.
And Judge, if I can just add to Mr. Shart's
All right.
position, the state, we've actually addressed this previously. The state agreed that this would not come in.
Okay. Well, I will find out what Ms. Love says about that, but I think that maybe Ms. Love hasn't had as much of a chance to study this in detail as she would have liked and as I would have liked. And so, Ms. Love, is that correct that y'all had already agreed that this part needed to come out?
And this part, I mean.
99, line 18 through kind of, I guess, what, maybe all of 100? 100, line 10.
Just 1 second. So I don't have an objection.
Okay.
Page 99, lines 18 through 23. And I don't have an objection with that.
Okay.
It continues on to page 100.
Yeah, go on to the next page through about line 10. It seems to be the same topic.
So we don't have any.
Frankly, 14, I think, or 15. Right? I mean, isn't that all the same?
15,
Okay.
correct.
All right. And so that would also encompass 99, line 24, which I think we accidentally left out of there. So, all right, by agreement, all the way through 100, line 15.
So that would be 99, lines 18, 24, all the way into 100, up to line 15.
Right. All right.
Now, Your Honor, if I could go off the list for a second, I believe
Sure.
one of my co-counsel has a objection to page 100, line 20 to 101, line 5. It talks about Jeffrey's family, how he likes to be in the hood, and he likes people that are going to be right there with him, same people he grew up with. And then investigator Dennis says, right, that makes you guilty by association. And that's improper, and And then they talk about Mr. Bennett's aunt being shot.
Okay.
Your Honor, the state has no objection to page 100, lines 24 through 25, but we would ask the court to listen. I think I have a different take on lines 20 through 23 than Mr. Sharp. I don't think he's talking about Mr. Williams' family so much.
He's saying though, I'm saying though, Thug is family. He likes to, yeah, okay. I can listen to it. Can we listen to it right now?
Regardless, it says he's hanging out with the same people he grew up with, and then investigator Dennis improperly.
Oh, yeah, no. She
Yes.
says she's fine with 24 and 25 coming out.
Oh, okay. And then that continues on to 1 through 4.
I think 1 through 4 can come out. We don't really need, that is not additive to the issues that we're on trial for. Okay. Huh? Let's just, yeah, you agreed, so. All right, so then.
Judge is over her. She's like, why are we here if you agree?
So 100 line 24 through 101 line 4 are out by agreement.
And then at 101.9, they start asking Mr. Zachary how he would feel if his mother got shot while she was asleep in the bed and all of those things. And I don't think that's appropriate either.
So Judge, based on the court's ruling regarding 1 through 4 up through 11 would be okay?
Yeah, all right. Well, you agreed with it. All right. So all the way through 101 line 11. Thank you.
I mean, it continues beyond 11.
Okay.
It continues.
Yeah.
But Judge,
Yeah.
with respect to the ones after 11, Mr. Zachary is saying his expressions, I believe, are relevant. I don't think that is the same
All right.
as 1 through 11.
And when you say his expressions, then you mean like facial expressions when he's talking, or what do you mean?
What he expressed, they just just shot up my cousin's house. I'm mad, and I don't disagree with respect to
Yeah, I think it goes to.
line 20. I don't mind all of that up to.
Okay, so now we're to 101 line 20 out by agreement.
Judge,
Yes.
if I may, the conversation continues on. It's this well beyond 101. I don't think reference to that incident ends until we get to page 102.
So maybe through line 8
I was thinking 18.
or 19.
Yes.
Okay. Yeah, I mean, yeah, essentially they're saying bad things happen. How would that make you feel? And he's not saying anything other than maybe how he would feel, but you can feel whatever way. Aren't these kind of hypotheticals? All right, so through 102 line 19 out by agreement.
next section.
So the next objection, okay, so that's carried us through 30 and 31 then, okay, right?
Yes.
All right, so we're now on item number 32, which starts on page 104, line 3, and goes to the next page, line 3.
And this is involving the Donovan Thomas case. And
Yeah.
I will say that in the other statement, Mr. Zachary asserts that Mr. Stillwell and Mr. Kendrick made some sort of statements against their interest
Okay.
as to who was in the car. But he never asserts that they told him about these details. And he's never claimed that he was there on Cleveland Avenue when he talks, here he's talking about a gentleman named Kelvin Treadwell, also known as OG Bentley, basically taking the guns and taking the car and disposing of those things. He never claims to have been there. And I don't think anyone's claimed he was there. He claims he was at a kid's party, and I think the state has accepted that. And he's never said that he got that information from Mr. Stillwell or Mr. Kendricks. And I don't know where he's claiming he got this information from, but until that is established, I don't believe that it's admissible, even as a prior inconsistent statement, hypothetically.
So, Judge, what Mr. Zachary said in his prior statement is that he got that information from two of the defendants on trial now. Following the shooting, at one point the night of at Mr. Williams' condo, and I believe the next one on the way to Miami. My memory may be a little bit fuzzy on that, but because he corrects one of the detectives when they're saying, so both of them told you at the condo. And he says, no, one told me at the condo, the other told me on the way to Miami.
Okay.
So our argument is that his recitation of what happened would have come from, he wasn't there, we've never said he was, would have come from the same place that he was made privy to the statements that we caught Nut down at, which was at the condo, on their way to Miami, because they were together. And by they, I mean various members of YSL. They didn't all go in one car together down there, but they traveled to Miami in the days after the murder. So
Okay, but this is about Bentley's potential involvement in getting rid of the guns, is that right?
So OG Bentley is alleged to have, yes,
Okay.
gotten rid of the guns after the murder.
Okay.
And our argument would be that Mr. Zachary would not have, he's not the only one that says that. They wouldn't, this collective knowledge wouldn't exist, but for his involvement in the gang itself. So this is another spot where I would say, where I would object to it coming out. But of course, I'm going to follow whatever ruling the court makes.
All right.
And I just want to be clear. I actually agree with Ms. Love's recitation of facts to the extent that he said that he got certain information from those individuals,
Right.
but it's not this information.
Yeah, I mean, it does seem like, I mean, he could legitimately have gotten the information about two other people saying they're involved, and that's one thing, and that's not what this is about. This is about what was OG Bentley's involvement And did he, get and hide guns? And literally, even on 104, like towards the bottom, and they're asking about, they gave him the guns. He's like, that's what I hear. He doesn't even seem to be saying, hey, I know this from one of my in-gang sources. He's just like, oh, I don't know.
In the 2015 interview,
Uh-huh.
a little bit more detailed and a little bit more statistics.
Okay.
References it. So at the very least, I think it.
All right. So how about if you can point me specifically to where in the 2015 thing it shows that he actually has the legit knowledge of this, then I'll reconsider it.
Okay.
Okay. All right.
So I'm just gonna put, okay, contingent on.
Yes.
And this would be all.
All basically 104 line, 3 through 105 line 3? Is that right?
Yes.
Okay.
104.3 to 105.3.
All right. So moving on to item number 33, which is a little portion of page 105.
So the state has no objection to 11 through 14 coming out.
All right. All right. So that takes us to page 107. Our first
I'm gonna withdraw that one.
34.
Yes.
Okay. And how about 35? We're still gonna sort out?
35?
Yes. Item number 35, which is 107 line 23 through 108 line 1.
I didn't remember talking about that one.
Well, it's in your list.
No, you said we're still gonna.
No, I'm asking you.
Oh, yes.
So that's what we're moving to next, right?
Yes.
Okay. Sorry.
I thought
Like,
you were
wait a
saying
minute.
we had already discussed it. I got it.
No. Okay. All right. 107 line 23.
Just a random discussion about a fight in a club that Mr. Kendricks allegedly got into with a man named Lil Tony.
Okay. Does that have anything to do with this case?
Yeah. No, it doesn't.
All right. Thank you, Mr. Shard. I'm asking the state now.
So actually, Judge, going back to 106.
Okay.
So 106 just gives sort of context of the time frame, but from 1 to page 107, line 1, when Dennis is asking,
Right. Is this about the time the beef's kicking off? Okay. Well, they don't have an objection to that.
So what it's going back to the gambling house shooting, and they thought the quote unquote the mob did it, but then we find out that apparently Kelvin Watts pillow talk with a young lady led to it being revealed that Kelvin Watts did it. And essentially they're asking, why did you think the mob did it? Why did you
Right.
mistakenly think the mob did it? Assume. And they're saying, oh, because Mr. Kendrick beat up one of them
Right.
named Lil Tony.
Okay.
And so I don't know why.
Okay.
And this is all around as Detective Dennis said, this goes back around, this is all around the time that
Right. So as I understand, the objection, it is to, well, it may be a little further up than
Right.
Line 23, right?
It really starts on 14. Why
Yeah.
did you think the mob
Yeah,
was
all right. So starting at 107, line 14 through 108, line 1.
So when Detective Dennis asks Mr. Zachary, why did you think the shooting was taking place? And Mr. Zachary is telling Detective Dennis, yes, he might be speculating about why they did a rival party did what they did, but he's also stating that Diamante Kendrick had just beat up one of them.
But this isn't, I'm sorry, it just for my clarification, this isn't one of the IF people, this is some other group, right?
Where it says why y'all thought Damara and then
Phonetic or something.
Right there on line 14.
Right.
If you listen to it, it says why y'all thought the mob was shooting, not Damara.
The mob?
The mob.
Okay.
And that's the gang that they assumed.
Okay. All right, so why do we need this? What is your position as to why this would be admissible? Line, 14 through the next page, line 1, hey, man, I mean, we thought for a while it was this other group because of this other beef that had gone down.
So as it relates to 14 through 17, we would stipulate to that. But line 18, where Detective Dennis says, y'all had beef all over the place. Y'all being his acknowledgement as he was to Zachary of them as a group.
Okay. And Zachary at 21 says, yeah.
Yes.
Okay. So then 18 through 21 seems like that legitimately could come in. And then that brings us then to 22 through the next page, line 1, about, okay, here are the details on this mistaken beef again. So that out, and then just 18 through 21 in. Because it seems like 20, you're okay with that?
So I don't have a problem with, you're saying 23?
22, yeah. Well, actually through the next one line on the next page.
Correct.
Okay, so thank you. Okay.
Are we at 109:23 now?
Yes.
Can we go through the exact?
Yes, so on the ones that I just said, okay, so if we go back to page 107, 1 through 13 are in without any objection. 14 through 17 are out by agreement. 18 through 21 are in over objection. No, was there an objection to that, Mr. Sharp? 18 through 21?
No.
Okay, are in because there's no dispute about it. And then 22 through 108, line 1 are out by agreement. All right.
And then we're moving to
Yes.
I have no objection to 23. I have no objection to 23 through 25 on 109. And 1 through 13 on page 110.
Okay. All right, which I guess means that if there is objection to 110 lines 14 through 19, is there?
Yes, because,
Wait, so y'all want that out?
no, we won't.
Yeah, so I'm asking the defense.
Well, if 14 through 19 is played, there's going to be no context to it at all. Because it starts with, they've been shooting at each other for how many damn months? And no one's even going to know. The last time we talked, they were talking about
Right, somebody
Nut
else.
and Greedy and
Okay.
Kel being half brothers. And
Right. So,
I mean, honestly, I'd be okay with. I've identified this as hearsay. I don't have any problem with it coming in, to be honest with you. But
okay.
you know, if the state needs to play 14 through 19, I just say play the whole thing and
Okay.
give context.
All right. So then that actually starts with 109, line 23, or no?
Yes.
Okay. All right. So basically, they're withdrawing their objection to that. Page 111, lines 7 through 9. Okay. What does the state say as to that?
That Mr. Zachary's response, no, just stopped messing with Woody. And the subsequent lines are important evidence in this case. Obviously, Woody is Mr. Copeland. He's the one on the stand right now. I can't,
Yeah. No, and he doesn't object to line 10 and 11 and 12. He objects to 7 through 9.
7 through 9 is necessary because they cause the response. That is line 10 through further down. And it is necessary, it is Mr. Zachary's reaction and response to Detective Dennis's question.
It's not a question, though.
Between.
Yeah, it is a question. I mean, it might not have a question mark at the end
Well,
of
it says,
I mean,
word I got is Shannon started putting in more work than Woody. That is a declarative statement, and it gives the impression that other witnesses have told Investigator Dennis that, and that I've never heard someone tell Investigator Dennis that, and even if they had, that needs to be come from the stand.
He starts out with how did Shannon.
yeah. So the how did Shannon part's really not a problem. I mean, could you redact out after the dash? How did Shannon? And I know we then don't have the word Woody in there, but Mr. Zachary provides the word Woody. No, Thug just stopped messing with Woody.
Why don't we just start with line 9, just with why Thug start pushing Woody? in?
That works. Thank you. Thank you.
Thank you.
One 13 line 23, 114 line 3. So do y'all, let me, before we dive into the substance of this, we're not gonna unfortunately get through the entirety of this one statement today. So we can look forward to doing more of this tomorrow. But there are, how many, two other statements? Okay.
I can provide all of them to the court.
Okay. Here's the thing is, I mean, some of this I am having to make rulings on, but a lot of it, it's like, it might be, and I'm not saying it's the first time you're looking at it, but it's the first time you're looking at it for the purpose of trying to think about whether you're okay with redactions. And that's not really the best use of court time, by which I mean time that we are all here between 9 and 5 in court. So can you endeavor, and I know this is a lot, but y'all should have done a whole lot of this before now. So can we sort of maybe by the time we all reconvene tomorrow, have a whole lot more of this sorted out so that y'all can hone in on the things that I need to make an evidentiary ruling on?
I have no problem with that. I know
Thank
that
you.
Mr. Sharp was endeavoring to give us another.
He's got, this list is great because I just need, okay. I need the responses to winnowed. All right, great.
Okay, he gave it to us for one of the other interviews. We need the last one. It's 3 of them.
Okay, well, do you have that one ready yet? Mr. Shart is ahead of y'all on these interviews, so maybe while y'all catch up through the rest of these two, he can be finishing the third one, if he doesn't have it yet.
I'm trying to remember. I'll talk to the state afterwards. I want to make sure I'm on the same page with them about the 3 different statements.
Okay. So I'm sort of thinking I don't want to do any more of this. How about that? Because y'all can maybe do some things to make it all easier. So I will take a look at the beginning of this video. Y'all, the state, are going to go through what you have so far, which is the rest of this statement, potential redactions, and then whatever the second statement, not in time, but you know what I mean, potential redactions, and have it crystallized more for tomorrow. And tomorrow we also, I think, can't remember what I told you to turn in by tomorrow, but what was it?
Your Honor, we do the open court exhibit.
Yes.
And I have a very nerve-wracked and nervous person working on that. They're asking, what if we don't have everything?
I'm gonna throw them in jail. I'm kidding. I understand this is a monumental task, which again, should have been done before now, but given that it wasn't, we're doing the best we can. If they do the best they can, it's not what we're gonna be dealing with, but it's not for me anyway, it's for the defense. So to the extent they have whatever they have tomorrow, turn it over, and then the rest of it by Friday. How about that? That seems reasonable. All right, what else?
And also, the court asked us at the beginning of the week to have the next.
Yes, the next tranche. Yes.
Yes. So.
Where are we on that?
We count, even that tomorrow night is the end of the beginning of the week, but I don't know. So we're
You're, okay, all right, I'll check in with y'all again on that one. Okay. Mr. Harvey is going to produce a potential 105 limiting instruction within the next couple of days before Friday for me to consider.
Will the court give the state an opportunity to?
Oh, absolutely, yeah. I mean, but we got to have something to at least start with. Oh, y'all are also all supposed to be thinking about what it is that we tell the jury about why we're starting over with Mr. Copeland, which may not, necessarily need to be a whole lot of detail, but we are going to be starting over with him. So it's going to be a disregard everything you heard so far, and then we either hear from him again or we don't. I don't know. We'll find out depending on how he wakes up that morning. But I'm gonna have, that'll be, it's gonna be a strike everything you heard, and then we'll see what happens next, But any kind of suggested instruction as to that as well,
They did all that work.
since we're starting over on him.
Okay.
Yeah.
So you're not talking about trying to offer it up and work it out now?
And no, I think, didn't some people have objection to any of that? Right? I mean, hey, if y'all want to, super, that's easier. But the gist I was getting earlier today was that there were some defendants who objected to that, and that it might be just cleaner to just start entirely over. And frankly, if he ends up, it depends whether he ends up testifying or not. So, I mean, yeah, I'm happy with if he ends up testifying and y'all are like, yeah, we're going to use this day, whatever, all of it, whatever. I don't care. But that's going to have to be because y'all agreed to it.
Your Honor,
Yes.
I thought the people charged here position was, and I think the state's position was just to include the 7th, which really was not anything, and then the 10th, which is Monday, the 12th, which is Tuesday, and part of the 11th, 10th, 11th, and 12th, part of the 12th, but nothing thereafter, not strike everything. There was a lot of exculpatory information on the 10th, 11th.
Here's the deal, though. And if he ends up testifying and y'all want to say those 3 days, great. But if he ends up, since what I am trying to do is sort of circumvent the whole issue of potential coercion and give him an opportunity fully and correctly informed to make a decision about whether to testify, then if he says, no, I don't want to, throw me in jail, then that means none of his testimony should come in unless everybody wants to agree to it, which would be kind of, an odd scenario.
If we don't get to cross-examine Mr. Copeland, we would like to strike all of his testimony under
Okay,
that
right?
circumstance.
Yeah, right. So, and then, if y'all want to try to call him as your witness, if anybody's calling a witness, then try that. I don't know. If you want exculpatory parts of it, but then that of course comes with risks. So it just, a lot of this is up in the air depending upon, I think if he says, now that I'm fully informed, which I am not saying that any of his decision before was because of any incorrect information. I just think, like he said, it depends how he feels when he wakes up in the morning. So, but anyway, yeah, in order to try to tackle all of the issues surrounding this, this is the best I have been able to come up with. So, so y'all be thinking about that.
Did Your Honor get the thumbs up?
Yes. magically. All right, anything else before we break for the day early? Because I'm gonna go do some work on it, not in court.
Just for your edification, we'll file a written motion. The state yesterday gave us a Dropbox link, and it includes additional telephone numbers that I was unaware of,
Okay,
where an expert, he's already been qualified. His name is Agent Bernie, Berni, from the FBI, has done now an analysis of historical cell site location data. And I'm objecting to that very late, I believe, notice. And then the state has a couple other, they changed charts. I personally don't have a problem with that, but I need to study them. But the new reports and data and a new phone number, I am not agreeable to.
okay, an entirely new phone number. Tell me some more, Miss Love.
Yes. So the new phone number there was another person in the vehicle during one of the murders in this case that investigators were still investigating during the time we began this trial. They were trying to hash out whether or not this particular person was even in the car, if you will, with some of the alleged parties to the crime.
Okay.
Since that time, during the course of this trial, the investigators with the Atlanta Police Department that were doing their deep dives into forensic data determined that this person, I don't think that person has been arrested, but this person was also in the car with the co-conspirators during this particular murder. We got it before now, but we got it after the trial began, like between, I think, January and now. And I think it was inadvertent that it had not been disclosed.
All right, can I stop you and get some clarification?
Yes.
When you say we got it, do you mean we got this report from this agent, or we got information that there might have been yet another person in the car and that person had XYZ phone number and that was going to be investigated?
So those are two separate things. The report from the investigator, from Detective Bernie, involved plotting.
Sure, I understand what that means. When did y'all get that?
We recently asked him to plot those two, because the green store is a thing that came up recently during trial, and the other location was. So we have two understandings of what the court is asking. So we're not talking about the plotting of those cell phone numbers. We're just talking about the Boyer cell phone records. We're just talking about the cell phone records.
I don't know what we're talking about. That's what I'm trying to pin down. So
there was.
Hang on, yes.
We were given cell phone records linked to a last name Boyer.
Boyd, B-O-Y-D?
B-O-Y-E-R.
Boyer, okay.
On Monday, on yesterday?
Okay.
Yesterday. And so that is the late disclosure that we're speaking of.
Okay.
And they were charted as well.
Okay.
Which leads
Nobody
me-
really I'm sorry, do y'all care, is the objection to the charting or,
It leads me to believe that they've had them for a while if they've plotted them.
all right, so the plotting of the cell site location information report done by Agent Bernie, that's of this Boyer phone number?
Yes.
Okay, and y'all just recently asked for that based on some testimony about something?
No, that's a different thing. I literally sat there and conflated two different.
Okay, all right, so then let's back up to the original issue. When did you find out that law enforcement believed that there was another person in the car and had a cell number that they were going to investigate with regard to that to find out whether, in fact, that was a reasonable lead?
Your Honor, I'd like to check with another team member.
Okay.
Because I don't know the answer.
Can you give me an idea? Let me clarify. You said about something that it was sometime between January and May, and that might have been that you got something. What was that about?
So the conversation that I had with the team member most recently, like 2 days ago, was that I have to turn over these phone records.
Right.
This person was someone that they believe might have been in the car.
Okay.
And they got phone records, and now we know that based on the phone records, this person was in the car.
Okay, so when did they ask for, we or they, not we, but y'all or they ask for the phone records because they thought that might be?
I beg the court to allow.
All right, find that out. And then, do you know when y'all got the cell phone records?
When you said I thought you were talking about us. I don't know the answer at all for the Atlanta Police Department, but I can find out.
Okay, so unfortunately for you, we equals, y'all equals, the state equals both the DA's office and the Atlanta Police Department. You know that, and I know sometimes there's a little lag in communication, but I need to know, was it, if they were provided to the defense on Monday, was it last week or was it 4 months ago?
Okay, I can find
No,
out.
because, okay. And what do these cell phone records reveal? That this person did appear to be also in the car?
Yes.
And
There's two cars.
okay, do you know which car? I mean, there are two cars that obviously one, well, not obviously, at least one contains at least one shooter, right? Is there any assertion that others contain shooters as well, or just people that are involved?
The state
Okay,
is alleging that there's a white car with my client and Mr. Garlington in it,
Right.
and then another car with Mr. Nichols and Mr. Farley in it. And now it sounds like they're saying that this Boyer phone, whoever owns this phone, was in one of those cars. And I'm inquiring what,
mm-hmm.
I don't know anything
I'd
about
like to provide that information, if I can.
You don't know, you want to check and make sure on that, okay.
Because it was not a part of the original. Yes.
Okay, how long has the defense known anything whatsoever about this person named Boyer?
Your Honor. Oh, that for this, I could tell you from my understanding of the discovery, there is zero information on Mr. Boyer except one mention in a jail call. That is it. That from my whole database, I have one mention. That is it. And I have no reports. So the police been investigating and found out that this person allegedly was involved in this killing. I still, to this day, have no reports on it. I've never interviewed him. I didn't open on him. He could be
Right.
a great defense. I have no idea who this person is.
Yeah, I mean, yeah, this is, I mean, you know, potentially significant information for the defense to know about.
I can't say that at the time we did opening that the police had it. I'd like to be able to say.
All right. All right, we'll find out, but there's been a long period of time between opening and now.
Mhm.
8
A
months
couple-
to be,
That was 24, okay.
7 or 8 months. So.
You should know already, girl.
Yeah, we need a lot more information about this. I love how y'all save all of the like bombshells for late in the day, right before we're wrapping. Y'all like going, hey, guess what? So, okay. I
They
mean,
do that.
It
They'll
is
do
what
it
it
every
is.
day.
Okay, so we'll need to find that out and put that on the record and sort that out tomorrow. Okay, so exhibits, next 30 witnesses, and then you also, I believe, we're going to get by tomorrow, actual, like a list to the defense of here's what we think is a co-conspirator statement, right? Okay, so we'll be waiting anxiously for all of those. Anything
Making
else?
this love work.
As if that wasn't enough.
Your Honor, somebody I wrote down said that there are 3 Mr. Zachary statements. I have 2.
Okay, and I might have misspoken. Did I misspeak? Ah, Miss Love misspoke. Did Miss?
I might have put a date wrong, but I'm talking about the 2015. I think it was August 2015. I believe March 2017 and the proper. So, I'm sorry. I might have misspoken too.
Okay, so you think that maybe there only are 2, but you'll confirm that for us tomorrow? All right, and so if there are only 2, then Mr. Shart, you've done all of the proposed redactions because you've done redactions to 2 full statements, right? Or proposed redactions.
I didn't quite finish the second one, but I don't believe that the state is going to be trying to use it. It's a discussion with ATF agents and.
All right, y'all, we're going to get together and sort that one out too. Okay. Sounds good.
And Judge, if the board needs to finish the court, just allow me to get this thing copied.
Just ready to go. It's over it.
Judge, I'm not gonna keep you on the bench, so I will have some.
All right, that's fine. That'll work. Thank you. All right, see y'all at 9 tomorrow.
We're gonna be right here streaming, y'all.
We'll be 8:45 at it when we have the jury. Okay.
It was a good day. It's been these last 3 days in court, y'all. Ooh. These district attorneys may lose their job. I dropped a link if anyone wants to come up and discuss, but I will just kind of give a summary over the last couple days.
All
It
right,
was
so we're adjourned.
all right. They're adjourned. They are adjourned. So guys, let me tell you, four things that have developed, right? They had an extra ex parte meeting. So everybody knows about the ex parte meeting that happened on June 10th that kind of blew everything up, got Judge Glanville kicked off the case and all of that. On Friday, they learned that there was another ex parte meeting that happened on the 7th. And how it came out, Brian Still is like, listen, Judge, at the beginning of this script, Judge Glanville is talking like it's a continuation of something, but we don't have that information. It's like it was another conversation. So the judge, she reached out to Judge Glanville's court secretary and asked her if there was another conversation that happened on the record or if there was another ex parte meeting, send it to me. And she sent it. And she then sent that to the defense attorneys. The defense attorneys were livid the next morning, like livid. Judge Glanville is in this June 7th ex parte meeting saying, yeah, I agree with you. I see what they're doing. Yes, these people are guilty. He said that one of the attorneys, the attorney for Lil Woody, was working with the defense. This is the judge who is supposed to be biased. He offered to have meetings with them on the weekends, knowing that there isn't a court reporter available. Like it was just really, really, really bad. And so many violations. So many violations. The Brady rule, like so many violations. So what the judge did, she allowed the defense to call Kayla Bumpus, the attorney who represented Lil Woody. She allowed them to call her and she testified as to what she witnessed in that meeting. I guess I can do stop sharing. Let me do that. So okay, good. All right. So she testified in that meeting that there was another conversation that happened where the prosecuting attorney asked the court reporter to leave it off the record. Judge Glanville was in the room as well. Like, so it offered up another piece of Brady because the attorneys will never know what was discussed in that room because there was a portion that the prosecuting attorney told them to keep off the record. So then Miss Love called the detective who was also there as her witness. Well, the detective ended up telling that they gave the guy the wrong information, that Judge Glanville was in the room too when he was talking with the attorney. Like he shed light on even more of the corrupt stuff. So much is so that the judge started asking him questions specifically, like she was tuned in, getting to the bottom of it. So then after that happened, Attorney Melnick testified yesterday because they tried to say Attorney Melnick was working with the defense. He came up and testified on yesterday, testified to that he was always the one representing Lil Woody while they trying to pretend that he didn't have representation. They went behind his back. He had even told them to stop talking to his client and they didn't. He had said that he was going to plead the fifth and they railroaded him. Like he told a lot. So the judge yesterday, she said, listen, we still have these motions regarding dismissal of these cases with prejudice, without prejudice. These motions are still here. I am not done with them. I take it very seriously. She said, I also take Brady very seriously. And everyone in this courtroom should take it very seriously. She told them that when I said that I was not going to remove them from the case, I was speaking to the bickering that was going back and forth, for lack of a better term. And I didn't know all of this stuff that was going on before. So I am reconsidering that motion. So she has those motions. She has two motions to dismiss and the motion that she's picking back up on the table of firing them from this case. So they come into court today, and Mr. Steele is like, listen, I want to ask Lil Woody, was he coerced? Like, we should be able to get his testimony and what he plans to do before the jury comes back. Like, we need to hear from him. Does he have representation? What is he going to do? Because we agree that his testimony is going to get thrown out. They can't use it. We agree that he has immunity still on the table, or he can plead the fifth. And he has the option to stay in jail, and not for everybody that's being fined. He has the option to go to jail just through the remainder of this case. The case could be dismissed by Friday. It could be dismissed by Monday. So let's get him in. Can you get him on the phone? Will he come in? Lil Woody came in today, y'all. But the judge said she wanted him to have representation. She said, I want him to fully understand, because he was ill-advised. There is ways for him to get charges brought against him. And I don't know if that was explained to him clearly. I need to make sure as the judge that he fully understands his rights, what is happening, what his options are, what could happen. So, does he have representation? And I don't want to state representation. So Mr. Melnick agreed to represent him. And Mr. Melnick was in by Zoom, and Woody was in court today. And she said, she explained everything, and she wanted him to know, like fully everything. She cleared up a lot for him. She was very patient with him, very nice. Woody, she said, so what I need to know from you is, are you going to testify, or are you pleading the fifth? You know what Woody said? It depends on how I wake up on Monday. We bringing the jury back. I'll let you know on Monday. Judge was like, hey, okay, that's all we got. You still sworn in. We'll see you Monday. So what does that do, y'all? That means that she still has these rulings. She is not happy with the state and what has happened. And she is out of court on Friday. So they're not having court at all on Friday because she has a previous planned appointment. So she will have all of Friday and all the weekend to kind of do these rulings. And I mean, and let's be clear, Woody is the key. So if Woody pleads the fifth and say, okay, I'm going to sit in jail, they don't have his testimony. They can't use any of that stuff. And it's so much of the evidence that Judge Glanville let in that she didn't let in. And even the stuff that she did let in, they have to put foundation for it to even be brought in. And you know how they played Lil Woody's interview or whatever, where he gave his confession, or when he was talking to the investigators, the 9-hour interrogation, that was illegal. She said, you can't just play that whole video because you have this issue with the client. So they went by that bit by bit by bit, and it's only a few of that can be let in. The jail calls, all that stuff. Lil Woody, I think that boy gonna get all these dudes freed. And if she has to dismiss these cases by prejudice, that means that everybody that pled out, they may be off probation and get off scot-free, because if there's no case to plead out to, all of that is going to go out the window. Child. The judge has really stepped it up, y'all. This is just also interesting to me. So I will be back. If no one wants to come up and give their commentary, are you watching this trial? What are your thoughts? I dropped a link, for someone to come up if they'd like to. I appreciate all the support today. This has been phenomenal. I just am so appreciative of everybody that dropped in, hung out with me for a little bit, stayed for a longer time. Everybody that's in the chat now, I hope you guys will at least give me a like while you're here. But I'm not begging. I'm just happy you're here. I'm coming off of my little vacation with my family. I'm going to catch up on some reviews tonight. I will be back here to stream this live. It looks like I get more people towards the end of the day. So I may break it up to where we're kind of, have it spread out so that the bulk of the audience get this time live. And so we can really get into some things. But y'all, this has been good. It is heating up, and the jury is not even back. And the way it's looking, they may not even be back Monday, with the defense having to keep bringing up more and more of things for the for the prosecution to keep having to submit evidence for the defense to even have time to look at. Like, it's really shedding some light on how they are unprepared and they don't really have a case. Good stuff. Very good stuff. So if no one else has anything for me, I got to get to these reviews, y'all, before my subscribers get really upset with me. So, I love you guys so much. I appreciate all the support, every little bit of support that you give me. I appreciate it. And thank you to my growing family. Look out for Bama Girl 2.0. We're going to be doing some lives, getting into more of the court stuff. The Sonia Massey case, I'm going to be following that. Of course, the election, we'll get into that. We're going to get into some true crime stuff and some Diddy-like things. Like, there's so much that our community can benefit from. So I'm really, really kind of carving out Break Bread with Duchess 2.0 into the way we like to see it. And Bama Girl 2.0 is right behind us, y'all. We doing this thing, busting it wide open. Probably shouldn't have said that. But anyway, it's your girl Duchess. I'm going to take a break, get a workout in, and come back with some TV reviews. And we'll get some more content out here for you guys. I've missed you guys so much. I love you so much. And I so appreciate you. Have a good evening. Talk to you soon. It's your girl Duchess. I'm out.